Welcome. So today we have a full day planned for you. This is primarily to help guide you through the stages of an officer's appeal for decertification. However, we are going to be providing you a little bit of background, how the cases get to the point where you are now seeing them in a public forum and deciding on the preliminary review and then again the final review. So there's going to be a lot of information that we'll cover today. And after we do a couple of introductions and opening remarks, I'll kind of give you a format for what today will look like. So right now I'm going to ask Chandler to do the roll call and we'll establish our quorum and move forward. Chandler.
Good morning. Commissioner Barcelona, Commissioner Braun, Commissioner Brazil, Commissioner Cooper, Commissioner Yule, Commissioner Gordon, Commissioner Long, Commissioner Moon, Commissioner Nieto, Commissioner Rodriguez. Okay, the board. Board Member Buchan, Board Member Clavo, Board Member Crawford, Board Member Doyle, Board Member Dudley, Board Member Glaser, Board Member Johnson, Board Member Lara, and Board Member Pena. Thank you.
Thank you, Chandler. So we've established both a quorum of the board and also a quorum of the commission. Now it's time for us to seek public comment. If there is any today, we'll be doing public comment in advance of the training. So this is time that we've set aside for members of the public who wish to comment on items not on the agenda, but those within the board and the commission's jurisdiction. I may ask members of the public to limit their remarks in time pursuant to existing policy. I may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. Members of the public who wish to speak are asked to limit their remarks to no more than 3 minutes each. Please be advised that the board or commission cannot take action on items that are not on the agenda, but only to the extent necessary to determine whether they should be made an agenda item at a future meeting. Respond briefly to the statements or questions posed, request clarification, or refer the items to staff. Members of the public who would like to provide public comment may approach the designated table and microphone at the front of the room. Please remember that this meeting is being recorded. Is there anyone who would like to address the board or the commission during the public comment period? When it is your turn, if you wish, please state your name and your organization. I'm going to open it up to public comment. Okay, seeing none, we will now move on to opening remarks. Now inviting Executive Director Manny Alvarez to address the board and the commission in advance of the training.
Thank you, Anne Marie. Hey, good morning to all of you. It's great to see you all here. This is a good one for me because I get to sit in the back and Anne Marie and Toby and Chandler get to do all the work. So I appreciate the opportunity to come and speak with you. Hey, we have almost a full board and a full commission here. We have one board member who's absent. She's out for a couple of months and will probably be back in May. That's Ms. Buchan. And then our chair of the commission is traveling for the month of February, so he's unavailable, but otherwise everybody's here. So it's great to see you guys. We're finally, I think we're really starting to get our bearings in terms of what we have and what we're doing. And I think you're going to see some, I don't want to say improvements, but more and more information coming out from Post in terms of what we're doing with decertification. So Anne Marie and her folks have been working with our computer folks, and we already have a template and a dashboard that we're going to be releasing on our website in the very near future and probably in the next couple of weeks with all the data that we've received from the law enforcement departments across the state. So you'll be seeing that on our website. We've been working on it since mid-December or November. We We're also working, again, Anne Marie's kind of leading the charge on a legislative report to give some context to that data. We're required to report to the legislature every year on what we have, what we've done and such, how many cases have come through. So that is also being done by Anne Marie and her shop, and we'll make sure to get that to you guys once we submit it to the legislature. We're also, I think, becoming more efficient in terms of processing cases. You'll see them, I think they're coming through a little bit faster to you all. We're also starting to build a bank of cases. I know you'll hear today, I believe, that the board's already heard 2 cases. They're going to hear an additional at least 3 cases in March. The commission will hear 2 cases the board will hear them in April, if I'm not mistaken, April. The commission will hear 2 cases in March. So we're really just starting to kind of move things along significantly, I think, in terms of all the decertification and certification actions. So I just want to thank you again for everything you guys do, for your service. These cases, as the board knows, can be somewhat controversial and somewhat difficult. They're not slam dunks by any stretch of the imagination. And I think you're going to see more and more of these cases that are difficult in the next few months. In that regard, I'd like to just kind of introduce Jim Grotkow to you, and then we'll turn it back over to Anne Marie. Jim runs kind of the legacy side of Post, a lot of the training that we deliver, the standards, the hiring standards and such for both peace officers and public safety dispatchers. The board has not heard from Jim. I know the commission has because he's regularly at the commission presenting new agenda items. But Jim, come on up. And thank you again for everything you guys do, and hope the training goes well.
Thank you, Manny, and good morning, everybody. As Manny said, I'm Jim Grotkow. I'm Assistant Executive Director of our Standards and Development Division. Just to give you an idea, and I think I did talk to you early on in the very first meeting you had, but I oversee our Strategic Communications and Research Bureau, our Training, Delivery, and Compliance. Those are the regional consultants that are out in the field, certifying courses and liaisoning with the agencies. Our training program services, that's our leadership courses, our legacy courses for our supervisors up to executive management. Our Computer Services Bureau, which includes pretty much the folks that are supporting you today, is all the computer and data, as well as our EDI, which is Electronic Data Interchange, which is the interface for the training, tracking, and hiring of officers. I also oversee our Management Counseling and Projects Bureau, which deals with guidelines. So like right now, and Emery will probably hit on it, we're working on guidelines for internal affairs cases so that we can have standardization in the field for what they do, so that when cases come before you both the committee, the board and the commission, that they have a more standardized review from the agencies. In addition to that, our Learning Technology and Resource Bureau, which is for most people, the learning portal, but also the great videos that we do. They've been award-winning, Emmy-winning videos that we've done over the years. And so I have a vast array of bureaus that kind of do multiple different aspects of Post. So primarily focused on the training side of the house, which is kind of our legacy program. So I want to welcome you this morning. If you have any questions of me, I'm more than happy to try to answer them. But if not, if you get them to Anne Marie later, I'm sure I can get you an answer to them. So
Jim, I have a question. I might have misheard something. Post is working on a training program for the agencies in terms of how to do the investigations to make those more consistent throughout the state, or am I missing that?
yeah, they're guidelines. So we're doing guidelines right now we're working on. So to give them some parameters of what they should be doing when they're handling the cases. We may, depending on how that works out, we may end up moving into standardization of curriculum of the course. Currently, there's not standardized, but essentially what we're looking at now is the first stage and seeing if we can give them some parameters when they develop the cases.
That seems very helpful for both the board and the commission, because we really, when we do get these cases, there is no standardized investigation process, and it would be helpful to have that. So delighted to hear that.
Yeah, thank you. And that's working in team with Anne Marie and her division too. So yeah, I think it'll be a good product when we're done, but we're just in the beginning. They met for the first time last week. So great. If no other questions, thank you and welcome, and hope you have a productive day.
Thanks so much, Jim. All right. What do you expect from today? Well, we hope we're going to be able to answer your questions. And I think primarily what I want to focus on here is this should be conversational. We should be able to talk about why the stages of review are what they are, what the limitations of the stages of review are, and how it protects the integrity of the case. And so a lot of this gets very technical, and I've asked the team to be careful that we don't get bogged down in the legalese because we all know what it means. But for practicality purposes, how do we execute this? How do you feel as board members and commissioners that you have enough information at each of the stages of the process to make a sound decision? And that's what we're here to talk about today. So this is just an overview of the things we're going to cover today. Some of this is going to be repetitive for many of you. The board has already been through training. Most of the members have been through at least introductory training. The commission has, most members have sat through 2 years of Senate Bill 2 discussions and know the ins and outs of the legislation, but haven't been through this more administrative training that we're doing today. So while some of it's going to be repetitive, some of it's going to be new information that I think we all need to digest. And there is, I think, nothing more important than having these practical discussions amidst the board and the commission about how these two groups really provide kind of the foundation for the appeals process and why the appeals process has been executed in the way it has in the statute to provide, we hope, equity, fairness, procedural justice, and all the things that we're looking for in these decertification hearings. So if there's anything that's not included here that you would like us to cover, please don't hesitate to ask any of the speakers to cover portions of your questions that may not be formulated in this training. We want to make sure you walk away with a sound understanding of what to do when the cases come before you. So as Manny mentioned, the commission's going to have cases on March 7th, the 2 cases that were heard by the board. I sent communication out to both the board and the commission separately about why we won't be discussing the details of those cases today, because they have not yet come before the commission as a governance body for review. The board will be hearing 3 additional cases on March 21st. Those 3 cases will then go to the commission in June. So the board's always going to have, obviously, the cases in advance, and maybe by 6 weeks or more. The cases themselves have been made a matter of public record because they were reviewed in an open session, an open forum. So there's nothing about the case in particular in terms of what happened at the board meeting that's confidential. However, the board should not prejudice the commission in its review as an independent governance body on March 7th. So we won't be going into the details. We will be talking about procedurally some of the things that came up. That's what we're here for. So I don't want you to shy away from talking about the procedural aspects of the review. And this is mainly for the board. Is everyone pretty clear on? Okay, good. All right, we're going to move on. So we've done some introductions. You're going to meet many of the POSAAB bureau chiefs today. When they come up to present to you, they will introduce themselves. You've met the executive team. And then we're also going to have a presentation from the Office of Public Affairs. The board has heard this before. This is all about when you're contacted by the media, or you're contacted by the sheriff's office, or you're contacted by a member of the law enforcement community, what types of questions you may answer and what types of questions you may need to refer to the Office of Public Affairs. So this is who the commission is currently. Shannon actually is not a ghost. She's here. We're waiting for her glamour shot, but she is here. We have 10 commissioners out of the 18 seats. And so I believe the governor's office is actively looking to appoint new commissioners, and we are waiting for those new appointments to come our way. And here's the first half of your board members. We have 9 board members that have been appointed, and that's a full contingent or full complement of the Peace Officer Standards Accountability Advisory Board. And the only one that's not with us today, he is still living, is Bob Dole. He just couldn't make today's meeting. And here's the other Regina as well is not a ghost. Wave, Regina, you are here in person. Okay, so we talked a little bit about how the executive office is divided in terms of divisionally. And we deal with on all of the certification, decertification, the Peace Officer Standards Accountability Division. And that's primarily who's providing this training for you today, in addition to our Legal Services Division, our lab, our Legal Affairs Bureau. And you'll be hearing a lot from our attorneys on the relevant topics related to the hearing procedures, appeals, conflict of interest, forum issues, Bagley-Keene stuff. And they promised they would keep this light and entertaining. So we're looking forward to. It's a challenge. Within the Peace Officer Standards Accountability Division, and again, some of this is repetitive, but this is primarily how it's set up. You've got your licensing side. That's your certification bureau. That's the people that are issuing your basics, your advanced, your supervisory, your executive certificates, and also now your proof of eligibilities. Foundationally, your proof of eligibility and your basic is what gives you permission to perform the duties and powers of a peace officer now in the state of California. Those are the things that post can revoke, which the other certifications will go with it, but those are the foundation certifications. Then you have your intake and disposition bureau. Think of this as your complaint intake. This is where the cases are reports of serious misconduct. They come through intake. They're reviewed for all of the identifying information that must be in place in order for the investigation to begin within the agency, within post. These are also the folks that handle the appeals and everything from the appeal through the final disposition of the case. So they're the bookends. And then you have your professional conduct bureaus that are broken up by districts. There are 4 of them. You're going to hear from 3 of the 4 bureau chiefs. And then we have a new bureau chief that has just joined us. And so we'll do an introduction at some point of Rob Guyton. He just started yesterday and he'll be handling our Northern Bureau. He hasn't met all of you yet. Rob, do you want to just stand up and say hello?
Good morning, everyone.
So he came back for day 2. That's a good sign. And he's already been in Mark 43, so that's an even better sign. Okay, I'm going to now turn it over to our bureau chiefs to go into the discussion of serious misconduct. Again, some of this is repetitive. We're not going to read the 9 acts of serious misconduct. You folks know what they are. But Christine Ford is going to go through some of those acts of serious misconduct that have been less clear for the field, more challenging for us as an agency to really define the parameters and what we're doing to try to seek some clarity for everybody involved. So Christine, I'm going to turn it over to you. Do you want a seat or are you going to maneuver?
Yeah.
Okay. Okay. Stand up there.
Okay, good morning, post commissioners, Chair Dudley and board members. Welcome. As Anne-Marie mentioned, I'm not going to read the definitions. You all know the definitions, but I do want to take the opportunity to talk about some of the cases that we've seen. We've now are into 13 months of accepting reports, reviewing reports, and doing investigation on those reports. So we have a pretty good grasp so far of kind of feedback we want to provide the commission and the board as far as some of the challenges that we've seen on some of the cases as they pertain to the definitions. So dishonesty, areas that don't necessarily fit in the definition. We have seen some cases come through, specifically a lot in regards to neglect of duty or failure to act. This could be an instance where officers choose not to take numerous reports when they go out on a call. And when they do a internal affairs investigation, the agency then questions them and they tell the truth during the IA. So in that context, that wouldn't necessarily fit within the guidelines we have for dishonesty. So we do see several instances of those cases where officers choose maybe not to take reports. They're neglecting to do their their duty or they fail to act in that circumstance. But in this instance, it does not fit within the guidelines that we have for dishonesty, because when they get called in on an administrative interview, they tell the truth and they say, you know what? Yes, I should have taken that report. That was my mistake. So that would be an example of that. We do have a lot of instances where we have dishonesty during an off-duty incident, where an officer is contacted by, let's say, an outside agency, and they're questioned in regards to some incident that's happened. And they don't necessarily tell the truth at that time. The agency does find out about it. They in turn start an IA, but they again tell the truth during that internal affairs investigation. So as you can see, there are some challenges that we may have when we get those cases from those agencies. Yes. Chair Dudley, go ahead. The instance that I can give would be, and for lack of better words, the officer may just be lazy. Be lazy. They choose not to follow up on an investigation where they choose to close the case and maybe don't write a crime report that goes to the DA. They just document the incident. So that's correct. Yes, sir. It's more information for the board and the commission to understand that when agencies sends us these types of cases, we would need to do follow-up. We're looking at these cases. If it does not fit the criteria, then it's a case that we would probably not move forward with. Again, it is dependent. Each case is different. We have different facts in each case. Anne-Marie, did you want to follow up?
I just want to remind the board members, if you're going to ask a question, can you press your green button? Because we can't hear in the back. So I want to go ahead and take questions and then.
Yes.
Hi.
Hey.
What bothers me is that, yes, the community wants everyone to be accountable and to be transparent in their discretionary, but the community is also calling for community-based policing, which in some cases, if an officer goes out on a call, and I'm just going on, seeing, hearing from people who filed complaints through my organization, where an officer goes out for a call. Is it necessary each and every time if it's just a call, let's say a cat is missing or, they've gone out to a call, do they have to mandate it? Are they mandated to do a report? And that's where it's clear to me. It only seems to become a problem when, let's say, that cat happened to get stuck in a tree and the owner got up there, fell down, and something tragic happened to him. But they hadn't earlier did that report. Now, would that be considered dishonesty or omission?
No,
It's not hard
in that,
for me.
in that circumstance, you're providing that would not be a circumstance where an officer would be forced to write a report. I think the example that I could provide to you would be if an officer is going out to a call and there is clearly, I'll give the example of domestic violence, and they choose not to take the report and they clear the call without taking a crime report. That would be an example of where we may get something, the agency has then realized that the officer has not taken a crime report that warranted one. It could be then a administrative interview in their own agency policies that it was a form of dishonesty, which they in turn submit to us. In that circumstance, that would not necessarily, in that circumstance, in that example that I provided, give us reason to move forward with that case. Because it could be an example of the officer was lazy, did not want to take the report, did not, there's a difference between that versus being dishonest and actually being dishonest in the crime report. If,
And so there's gonna be, in the process, there's gonna be where this is clearly defined, because I can see where it could be probably taken out of context when we leave it like an open, leaving it open, what we consider dishonesty and what maybe they may consider dishonesty. I just would like things to be clear. I'm sorry.
No, that's okay. Well, this is why we're doing this. These are good questions. I just want to speak to a couple of things. So the definition in statute is limited to investigating a crime and then during the course of an investigation if they lie, essentially. There's all these other areas here. And one of the requests of the commission early on was, look, we're not ready to do a broad overarching definition until we have some experience in what are we missing? How are these definitions not serving us well in terms of being able to take appropriate action? What Christine's highlighting is some of the things that we're seeing that don't fit nicely in that definition today. Failure to act, neglect of duty, some general dishonesty that happens, they lie on their timesheets, they say they were working, they weren't working. There are things like that that happen that may be appropriately addressed at the agency level and may not rise to the level of serious misconduct for the purposes of decertification. Does that make sense? Okay. And then there may be circumstances where we see something that's clearly egregious that doesn't fit one of our definitions. When we get to that point, there is an opportunity for us as an agency to expand the definition. It has to remain within the confines of the statute. So if it requires a law change where dishonesty might at some point, then there may be a reason to advocate for that. What we're doing is providing you examples of things that the agencies are reporting to us that don't necessarily fit in one of our 9 acts. And the agency may seem concerned that Post isn't doing anything. And you guys have probably heard, hey, we submitted this, Post isn't doing anything. Well, it's not a matter of Post isn't doing anything. It's a matter of that it doesn't fit within the definition. And that might be okay because it might just be agency discipline, or it might be a call for us in the future to look at our definitions. And we want to make sure you guys are aware of some of those things that are happening. Does that help clarify? Okay.
Board Member Laura, go ahead.
Quick question, so dishonesty to a supervisor kind of piqued my interest. Are we talking that sort of time card or day off, or I left this time versus that time?
Yeah, did you have a question?
Tragic consequence, oh, sorry, I'm sorry. Tragic consequences. In other words, domestic violence report wasn't written. The person then gives truthful statements when they're asked about it. But then because there wasn't a report filed, the next person that comes along where there's a domestic violence call doesn't know the history, doesn't have a background that it has occurred before, and so doesn't go prepared, and there's tragic consequences. What about in that instance, where the failure to write the first report results in something that where there's like true harm?
I think that would probably have to be addressed through the agency and possibly the district attorney at that point. And then Post would be sent if there was an applicable serious misconduct allegation after that fact. But that would then turn into the agency and the district attorney, I would believe, at that point. Are there any other questions for dishonesty? Yes, sir.
Yes, Cephas Johnson. I guess my concern would be, we have a use of force incident where it's an officer involved shooting. And the officer fails to provide the report. But then that's not the end of it. You know, he justifies that he was a little lazy. But then there's a second officer involved shooting, and the same officer fails to provide a report. Would that raise flags for us?
I think in that instance, on a serious incident like that, you would, supervisors and all of command staff would then get involved with that. I think in the examples that we want to provide to the commission and the board is that they're more lower level incidents where the officer has some discretion on whether they follow up with that case or not. So in that instance, I don't think that that would be a concern that we would be addressing today.
If I may, as a matter of practice, generally speaking, officers or deputies won't be writing their own reports when they discharge a firearm. That is going to trigger high-level investigations. Generally, a homicide team is going to be called out. The officers are not necessarily writing their own reports when they discharge a firearm. That's a significant use of force, and it's obviously documented at a very high level, just informationally.
Okay, the second allegation is abuse of power. I think the only comment that we would have on abuse of power is most of the cases that we do see, it's the officer using their position to gain something. So you see those bullet points. In addition to, it's usually those instances where officers are trying to obtain something due to their position. Physical abuse, not much feedback on that. That's basically our number one allegation that we do receive cases on. Sexual assault, I know the commission has talked numerous times about the definition. Some things I just want to mention is the commission, and we've in discussions, you know, most of the allegation and the definition is very specific. It has to happen on duty. But we do get cases where the officer has met a person on duty, and due to that contact, they didn't follow up off duty. And that's where all the propositioning occurs. So if you look at the definition in those instances, it would not be applicable under that current definition. So we have contact that's made with the officer on duty, but then they do proposition them off duty. And then all the stuff occurs off duty. So just something to think about. Also, we put in their rank or power differential. I know the commission has talked about consensual cases, not necessarily something that we would consider, but there are cases that we do get where a high-ranking official is in some form of relationship with a lower-ranking person. And does that make a difference? I just throw that out to you. I'm not going to comment or give any sort of feedback on that, but just something to think about. Demonstrating bias, we have proposed an addition to the definition based on some feedback from the commission. I believe that is just past the open comment stage, and we're in the final stages of putting that through 1205. The only comment that we have on this one is we do get a lot of cases that involve EEOC. And so our consultants have to kind of maneuver through that, determine whether is this a EEOC complaint or is this a demonstrating bias allegation that we need to consider and investigate. So example of that obviously would be like a hostile work environment. We see a lot of those cases come through where it's hinges on a hostile work environment, comments that are made. Does that now fit under demonstrating bias? So those are things that our consultants have to continuously maneuver through with the definitions.
Why is age discrimination not a part of this?
Toby, go ahead.
Sure. So this is one of the challenges that we always have when the legislature gives us a statute and we have to try to interpret what the legislative intent was. So the statute prescribes an instance where an officer engages in an act called demonstrating bias on the basis of a protected classification. And the question that we have to face is sort of looking at the intent of the legislature. EEOC claims and DFEH claims, in other words, just classic employment discrimination cases, which tend to be certainly viewed and handled on an internal agency specific basis, and sometimes with litigation with those administrative agencies, the DFEH or the EEOC, and sometimes in civil court. And the question is, under what circumstances is that sort of an instance, in other words, a purely internal EEO type instance between an officer and usually another member of the department, under what circumstance did the legislature intend that to rise to the level of serious misconduct? There is, of course, as I just mentioned, there is that separate remedy. So if it is a DFEH EEOC, the individual has a remedy. They can go to the DFEH, they can go to the EEOC, they can file a complaint. They can file a complaint with the department as well, and then also file a civil suit if they want to do that. So the question is, did the legislature intend for this to be a duplicative, an overlapping remedy? Or was the legislature really looking at instances where an officer is engaging in that conduct in the field? So abusing the power that the agency gave him or her and demonstrating bias. For example, racial profiling would be an instance where that officer is using the power that he or she was vested with and misusing that power by taking race or gender or any other protected classification into account in that action in the field. And so that's the challenge that we face, and that is the extent to which, if we get a case and it is purely an EEO type complaint, is that something that the legislature intended or wanted us to look at to basically have a whole nother administrative remedy for processing that purely internal discrimination case? Or was the legislature really wanting us to look at instances where an officer is using it in a way that shows biased policing? So that's the challenge.
Member Glazier, go ahead.
Circling back to Board Member Pena's point, age discrimination is a real thing. So specifically, the question was why isn't age included? And I can imagine a scenario where an officer might be dismissive or disrespectful of an elderly person's claim or a very young person's complaint. So is there, and I think it raises a larger question, which is, are we limited to these categories or can we go beyond them?
So we are limited by the legislature. And so anytime a case comes into the division has to look at the facts through the lens of what the legislature gave us. And this is one of the things we were talking about earlier with dishonesty. We have some cases where it's very clear that this is an officer who engaged in dishonesty, and people probably would not want that individual to be a law enforcement officer, but the legislature has not allowed us to conduct an investigation under those facts. It just is not what the legislature gave us. So the truth, the unfortunate reality is that we are stuck with what the legislature gave us. And if we're finding these holes, then there's two possibilities. Number one, there are some instances in which the commission can regulatorily expand upon a serious misconduct. And the other is, and there's some instances where it can't. And then in any other instance, we have to wait for the legislature to fix it and to give us the authority to go after certain forms of behavior as serious misconduct.
Marie.
It might be good, Toby, if you can give an example of what would rise to the level of the EOC, but not rise to the level of serious misconduct.
Okay, let me think. It may very well be, let's say, and boy, you're going to get me in trouble, Joyce. So thank you for that. I appreciate that. So it may be, for instance, let's say there's a circumstance where an officer has decided that well, let's say it's a he in this instance, would love to date another employee of the department. and says, hey, I'd like to go out on a date with you. And that person says, no, I'm not interested. And then the officer says, the next day, hey, I really do want to go on a date with you, right? And so after 3 or 4 or 5 instances, clearly the law would say, you can ask a person once, but any other times it's clearly unwelcome and it can become harassing and a violation of the law. That would be a case where it certainly, well, it likely would violate the agency's zero tolerance policy. It may very well violate state or federal law if it rises to the level of harassment based on sex. But that may not be a classic example where then does Post want to step in and say, because this individual used bad judgment in asking this person out on 2 or 3 occasions, is that an instance where we want to remove that person's ability to be a law enforcement officer in the state forever? So I guess that's the best example I can come up with off the top.
Got it.
Okay.
Anne Marie.
I'm just going to close the loop really quick on the age discrimination thing. So other protected statuses would include someone that's of a certain age, and that is part of the definition. So it's not exclusive of that. It just wasn't called out, but I think it is within our purview as part of the definition. Welcome.
Board Member Hatcher Crawford.
Excuse me, I'm sorry. We recently knew that AB 449, I was looking it up because we've been pushing it out to law enforcement that adopts the hate crime policy. It goes into effect July 1st, 2024. And it kind of crosses over on what on this regulation 1205. And I guess my greater concern is that a lot of times that when legislations come down, then a new one comes down, that kind of get mixed into the bowl and stir up again. It's not clear to probably the officer or to the agencies. And just even recently, I was surprised that some of my law officers didn't know this was coming down. So now we're gonna hold them accountable for Regulation 1205, and then when AB 449 comes up, it's just not really clear as, in my opinion, this is my opinion, on how we plan on holding anyone accountable for demonstrating biases. Anytime you discriminate. It's either black and white. And when you talk about EEOC, and to the point of Board Member Pena, it should be included in this because it could be subtle or it could be direct. And so I'm just asking for more of a clear, concise policy as we introduce this to the officers. I just felt like the whole time I was listening, I was taking it in. I understand EEOC very well. I also understand 1205. And then when you start mixing all these things in there, I just kind of see it's going to be a problem for officers and for agencies to take this in and then understand exactly the position opposed. That was just the only thing.
Did you want to comment, Anne Marie?
So this is, Regina's going to continue to be a really difficult aspect for agencies, for the courts, for Post, because it is more nebulous than it is concrete in terms of action, reaction, intent, and overall end result. What we did here, and this, just to be clear for the commission, they will be seeing this definition on March 7th. It's not been adopted yet. It's just gone out for public comment. This was an attempt by our staff and with the commission's approval to try to give some guardrails around when we get a case and we're looking at the very specific facts of this case, because it's really going to be fact dependent, right? There's no clear answer. We could do a bulletin to the law enforcement field and give them all kinds of words, and it's still going to be incredibly difficult to parse this out because it's really about the facts of the case. What were the actions of the officer? Can we in any way look at motive, intent, prior actions that may give us some indication as to why this particular person at this time in this situation. All that being said, I think, again, as I mentioned, the courts are struggling with this, right? When someone's taking action against an officer or anyone for a implicit, explicit bias, is proving that the reason the individual did what they did was solely based on an individual's protected class. And so I don't think we're unique. I think we're going to continue to struggle with this. What we're attempting to do is give ourselves some direction so that when we bring something to the board and then the commission, and we can, I think, affirmatively say, we have clear and convincing evidence that based on this pattern, this behavior, and this action, we believe the individual was acting in a biased manner. And then it's up to the board, the commission, and the court to determine whether we really met that burden of proof. And I think over time, having some of these cases heard and seeing some precedent decisions, we're going to get more clarification. And I know that's not a great answer for you. It's just a reality.
Actually, it was a great answer. And it was a great answer because we're diving into something like you said, that's kind of out there. And we have been seeing in the courts, where a lot of EEOC cases go up. And to me, they usually exhaust the system. And in exhausting the system, it doesn't benefit the accuser and, maybe I'm saying it wrong, the defender, no, the person who's making the accusation. No one's ever felt whole in doing this. And I felt that this regulation 1205 was to kind of give some foundation of what we see. Great. I think it's wonderful, but always again, is the accountability piece. And I've had a case where in Ventura County, and it's, it's not gonna go to the board, where officer complained about a noose being hung in his locker. And it was one of the hardest things for the NAACP to even get our hands wrapped around it. And there was no accountability piece of it. And we couldn't even push it any further to show that it was an EEOC case. Point blank, it was. But in the end, the officer or the party involved didn't seek or get a clear answer. Now, taking this up to post, are we going to hold officers to the point where they lose their credibility over these incidents? And that was my concern. But yes, your answer was great. Thank you.
Okay. Acts that violate the law, as you can see in the first bullet point, it's defined as acts that violate the law and are sufficiently egregious or repeated. So I just throw this out to you, challenging areas. What's sufficiently egregious mean? That's for the agency's own interpretation to some point, right? So considerations are, do we want consistency amongst our agencies when we're receiving these reports? Because if you were to Google the definition for egregious, you're going to find 3 or 4 different definitions. So, and the other consideration too is we do get a lot of cases where it's a one-time violates the law, but it revolves around welfare fraud, timesheet fraud, workers' comp fraud. Is that what? And so I just throw that out to you. I don't necessarily have the answer for you. I just want to throw that out that this is challenging at points of trying to get the agencies to consistently be on the same page on what they submit or what they don't submit. Participating in a law enforcement gang, I would say as a whole, we don't receive too many of these reports. No issues on this allegation. Failure to cooperate. These were questions that kind of initially got brought up in the beginning when we started taking in reports. We got a lot of questions from agencies. Hey, is this applicable? Can we Can we do this allegation if an officer resigns prior to an an interview? We do not move forward with those cases, and the agencies are not submitting that for this purpose. We do not get very many cases in regards to failure to cooperate, but there is a question that begs the question, and for you to consider is what if we do call an officer in, and by the instruction of their attorney, they tell them not to answer any questions, even if there's no legal basis behind that? Is that something that we would consider the agency to submit on that? I don't necessarily have the answer for you, but in cases where post initiates or post investigates a case and we call the officer to interview and they decide not to cooperate, this legislative definition gives us the authority to then do a failure to cooperate if it's applicable. So, Member Glazier?
Thank you. This issue of whether or not it's applicable if an officer resigns prior to an IA interview, that seems like a pretty big loophole. And I'm wondering, and I can understand why we wouldn't have full clarity on that, but I could imagine that I would hope that we would want to move toward some clarity on that, because we don't want seriously misbehaving officers to remain certified just because they resign prior to investigation.
Yeah, this conversation came up yesterday where, let's say the agency does an internal affairs investigation and they bring the officer in for an interview, the officer shows up and they basically don't answer any questions. So they get terminated for insubordination. That would be, from what I understand, probably what the agency would do at that point. They would terminate for insubordination, but insubordination is not part of serious misconduct. So there is discussion around this topic that could further in the future about maybe closing, like what you have said, a loophole.
There's another issue, I'm sorry. When an officer is investigated we are now mandated to complete investigations under SB 16. So while the officer is within their rights to resign, the agencies are under the mandate to close that loop, to make that finding, and so that that officer or deputy will be held to account, whatever the investigation will take place, whether or not they're without them there, even if they resign.
Sorry to just to get a little more clarity on this, is there some kind of threshold that determines whether or not that investigation would have to go forward? Would there have to have been some complaint made officially? Is there another way around that, a workaround? Because if that's exhaustive, then this isn't going to be too much of a problem, because if they're going to continue to conduct these, then they're going to have to report the misconduct, I presume.
Yes, agencies are required once an IA is started to complete it based on SB 2. Follow up, Anne Marie?
So Dr. Glazier, initially, I think we don't see this as often, and it could be because usually when there's a resignation during a pending investigation for serious misconduct, there is another avenue that post will take in terms of the immediate temporary suspension that's issued by the executive director. And that is more often what we see in the case where the officer resigns in lieu of, right? So we can close the loop. And then we then have to investigate that ITS all the way through the end product, whatever that is. So whatever were the allegations that led to the officer not cooperating, that's what we're investigating. So the end may not be a failure to cooperate. The end may be excessive use of force or dishonesty or something else. But I think we are closing the loop right now with that other immediate temporary suspension. This is just, again, where agencies may be closing the investigation as insubordination or something else, and then we're doing a different path.
Okay. And then the last one we have is failure to intercede. Again, not too many cases were received for this allegation, so not a lot of feedback on that. So if there are any other questions about serious misconduct, the allegations and the definitions, I'd be more than welcome to answer them. Okay, I'm going to have Bureau Chief Brian South come on up.
Thanks, Christine. And what we're going to do is we'll probably go another half hour and then we'll take a 10-minute break for you guys. I just want to get through some of this background information. Again, I know some of this is super familiar to the commission, and the board's heard it probably once, but it bears hearing it a couple of times, especially as we go through some of the experiences now that we've had over the first year. So Brian's going to take you through procedurally how a case gets to you. Thanks, Brian.
Hello, good morning, everyone. My name is Brian South. I am a bureau chief for Professional Conduct Central Bureau. So Central California, from the Bay Area down to San Luis Obispo and over to Inyo County is what I oversee. So this slide that I'm going to cover is about the retroactive reporting and what is actionable versus non-actionable. You may have seen this before, so I'm not going to take a lot of time, but I do want to break this down because you may hear the term retro non-actionable cases. And I want to explain what that means and talk a little bit about the numbers that we're seeing. So as we all know, agencies are required to report to post starting January 1st, 2023. But in the statute, it included additional retroactive reporting going back a few years. So from 2020, 2021, and 2022. The statute also said, but of those reports that the agencies have to make going back in time, there's only certain ones that we are statutorily authorized to take action on. That's what I want to talk about. So we've found the best way is just to put it up as a visual and break it down. So I'm going to start on the right-hand side of the screen first, which is 2022. That's the most straightforward. So any retroactive reports, cases that we've received that occurred in 2022, all of those are actionable. And when I say the word actionable, it means we can statutorily take action. It doesn't mean that we will take action. It means that we can take action. So for 2022, all of these areas, and Christine just went through all 9 areas, they're all actionable. Where it gets a little interesting is 2020 and 2021. In the statute, it says we can actually only take action on 3 of those serious misconduct areas. So that's right down here on the bottom of the left-hand slide. 3 areas we can take action on: dishonesty, sexual assault, and deadly force that results in death or serious bodily injury. Those are the only 3 areas of serious misconduct we can statutorily move on if the incident was from 2020 or 2022. So what does that mean? These other ones up here, up top, we can't take action on if they're from 20 or 21. Regardless of what the finding was of the agency, regardless of what our own opinion on the case may be, we cannot take action. And just to give some context in the numbers, we've received quite a few reports, right? Statewide over this past year, thousands have been analyzed and determined to be retro non-actionable. Thousands. So just a little bit of context, we have quite a few of those. We analyze them, we make sure that they're not actionable, but then we administratively close them. Now there's one interesting caveat that could make some of those up here actionable over here. And what that is this little asterisk down here. If the agency made their final determination on a case that's from 2020 or 2021 into 2022, it becomes actionable. So if one of these up here occurred in 2021, but the agency made their final determination on their investigation into 2022, it moves over here and it becomes actionable. So we have to do some analysis. We do pull all those documents, we look at them, and we analyze it to see whether it's actionable or not. And what happens is if it is actionable, like I said, it doesn't mean we will take action, but Mike Radford, another bureau chief, is going to come up a little later and is going to explain what does that look like as we go through that internal process. So that is actionable versus non-actionable. Are there any questions on the retro reporting? Yes.
Yeah, I was listening to a YouTube video concerning what you just spoke about. And I forget the numbers that were retro that came in, that was analyzed. And out of that total number, I think it was 12 that became, that fit into the category that justified the action, right? So I'm interested in knowing what the final count was, if there is a final count, and how many actually were decertified.
So are you talking about ones that were determined to be actionable and then how many of those we move forward on?
Right, so
Gotcha.
first, how many of those actually came in that was retro? I think it was 59,000 or whatever, right?
Not quite that many, but quite a
Right.
few.
Right.
Yeah.
And out of that group, there was a number that was considered actionable, right? So we'll just say whatever that top number was, what percent came out that was actionable? And then how many did we move forward on?
Very good. We don't have those numbers at our fingertips right now, but we are pulling data as we speak to do a presentation to the commission. And we're going to have that. So maybe we can make a note of that to include as a data point if what we have now. A lot of those are still in progress. So we have investigations that are in progress. So we're not going to know exactly what the end result of all those are, but I'm sure we can pull numbers specific to the retro cases.
The follow-up question is, many of those are still in process, meaning that they have entered 2022, meaning that now all 9 are actionable items. Is that correct?
We do have examples of that. Absolutely.
Okay.
Yep. Any other questions? Thank you. I think Anne Marie's going to talk a little bit about the future legislative fixes, and then Mike will talk about the internal process.
Okay, so this is new information for everybody. And these are just some things to highlight areas that as we continue to work with legal and we get calls from members of the legislature about Senate Bill 2 and our progress and some of the challenges that we are facing. We are keeping track of those, obviously, because we are going to have to report back to the commission. What are the challenges? What are our recommendations for closing the gaps? And why is it important in terms of the administrative work we do? So there's something that's missing that if we talked to the commission about, I've mentioned it to the board, and that's disciplinary guidelines. You guys might consider it a bail schedule. You might consider it a disciplinary matrix. Disciplinary guidelines for the purposes of administrative review provide our judges, our administrative law judges, some guidance because they will, and they have affirmed this, issue a proposed decision with the imposition of discipline. If we do not provide them guidelines, it's a shot in the dark. And in some cases where we have chemical dependency, substance abuse cases, ALJs have been primed for years, administrative law judges, to look at these cases as rehabilitation cases. What are we doing to get the individual back to a place where they can perform the duties safely and effectively? So as opposed to a straight decertification or revocation, it's what types of terms and conditions are appropriate. So we are in the process of putting together some proposed disciplinary guidelines for the commission to consider. This is not something that's germane in law enforcement, but it is very much so in all other professions where you have licensing and enforcement. The administrative law judges are very accustomed to seeing disciplinary guidelines because they use these as the basis by which to measure the egregious acts that have come before them to determine an appropriate penalty. So we hope to have something before the commission in June to consider. Again, our parameters right now, according to the statute, are revocation and suspension. But your term of suspension is up to 36 months. So what would make a term of suspension 12 months, 18 months, 24 months, 30 months? How are we going to apply some level of consistency and relevancy when we're making those decisions? Disciplinary guidelines should help in that regard. There's also a loophole with immediate temporary suspensions, and that is the IA has been conducted and then the officer resigns. So right now, our executive director can issue a temporary suspension if they resign prior to submitting for an interview, right? They resign in lieu of, or they're terminated. But this is, and we've seen this, what if they resign after the IA? There's no ability for us to do a temporary suspension in that case, unless we are dealing with a felony arrest or an indictment. And then on the felony arrest and indictment, there are times when there's actually no technical arrest. It's considered like an information. but they are being charged with a felony, the law currently says they have to be arrested for a felony charge. Yeah, so there's a little sliver there where if there's no arrest, do we really have jurisdiction in that regard? And then we talked about some of the other acts of serious misconduct, so we don't need to go into those to any large degree. The one thing I will mention here, and this is not in the time and the place to have an exhaustive conversation, but I do want to put it in your minds because we will be having an exhaustive conversation about this at some point. And that's mental health considerations. And the reason I bring this up is what we are seeing to some degree of frequency is prior to entering a plea, an officer will request diversion. So there's no plea. They go into diversion, and their means by which they're requesting the court to consider diversion are, I have some sort of post-traumatic stress disorder. I am considering using my weapon. I have visions and dreams about injuring someone, getting involved in an officer-involved shooting. Those types of things we've heard, and we get the court records. And yet there's nothing that post can do at this point to intersect that. Because there's been no plea, and we don't have the provision to say, hey, we need to put this person on a temporary hold until we can figure out whether or not there is truly a mental health consideration that is obviously a risk to the public. So these are discussions that are ongoing. I throw it out there because it is something we're seeing with some degree of frequency. And I think we've kind of gone over this with the dishonesty provisions. And that is, oh, no, this is separate. I'm sorry. So we have situations where an agency does not feel as though there are certain documents that post should have possession of because post in and of itself is not a law enforcement agency. And we have encountered times where we're conducting an investigation and the agency will say, I'm unable to send this documentation to post because I can only share this information with another law enforcement agency. So we need to look at what it's going to take for us to close that gap, because some of that information is extremely relevant to the findings of the case, and post will need that information in order to bring that forward to the board. So those are among the high-level situations that we're encountering in terms of decertification. Now, in terms of certification, the idea of universal licensure, which sounds probably foreign to some of you, is not all that foreign in other professions. And what it means is if I hold myself out as a peace officer in the state of California, I have to hold some form of certification where there's oversight by post. Right now, there's a select number of officers under the penal code that fall under Senate Bill 2. It's not every peace officer in the state of California. So we will at times get complaints and public complaints, or an agency will submit a report on a law enforcement officer that does not fall under one of the penal code sections that encompasses all of the provisions of Senate Bill 2. So the legislature has asked us this question. First of all, why? Why don't we govern all peace officers? And shouldn't we govern all peace officers? Is that what the public expects from post? And then there's a great deal of consideration here. We don't even know who all of these peace officers are, frankly. And some of them have very, very limited authority. So it's not a full-fledged peace officer that can effect arrest and issue search warrants and detain an individual. But there is discussion around whether or not post, it should be an all or nothing. If you hold yourself out as a peace officer, that means something. And this isn't so much about title protection, but it's about public protection. So just things to keep in your brain for future discussions. Any questions before I turn it over?
Yeah, again.
Yeah.
Back to that same YouTube video, which I heard your response in it. So if I remember correctly, there are 609 agencies.
Yeah,
That are-
614, that's pretty good.
614,
Yeah.
okay, under the jurisdiction of
I
post.
might have added a few since we talked.
Yes, And then there's maybe 20 agencies that are not up under post. In other words, their
They're not
officers.
post-participating, correct? Yep.
And you were basically referring to those.
No, actually, those 20, for the most part, don't participate in the post program for reimbursement for training, but they do fall under Senate Bill 2.
Okay.
Outside of that's a good question. Thank you for bringing it up. Outside of those 20, there are law enforcement personnel that work in the state of California that don't fall under the provisions of post, don't fall under decertification, don't have to have a proof of eligibility or basic certificate. And so it's confusing for the public, and that's kind of what we're talking about. Does anyone have any questions about it? Because I know this is kind of just other stuff that's out there, but it does impact the work we do, right? Because we will get public complaints about it. Okay, so the last thing I want to show you before I turn it over to Mike Radford is this is where our current statistical profile, this is the current statistical profile. And Mr. Johnson, Board Member Johnson, to answer your question, I think we're somewhere around 69% of our 22,729 reports of serious misconduct are actually look-back cases. So we were writing somewhere around 68, 69%. So that's a huge chunk of that 22,000. Something that Brian South brought up that I think is very relevant to the discussion of stats, and the commission has asked us for this a couple of different times. And that is, of that 22,000, what's our best guess on the number of actual cases that rise to the level of serious misconduct and fall within one of the 9 acts and are actionable? Based on an initial screening of all these cases, we're looking at somewhere less than 2,000 cases. Now, it may be more once we dive in and do a deeper dive, but based on an initial screening of sustained allegations by the agency for one of the 9 acts of serious misconduct, you're looking at less than 2,000 cases of the 22,000 reports. So this kind of puts the numbers in perspective, right? There's a huge dump of information that came in very early on because of the look-back provisions. Arguably, the law did not require post to essentially take in all those reports. The law said that there's only 3 that are actionable that post needs to do something with for the look-back. We took it upon ourselves to take on the report so that we could have kind of a historical knowledge and database of the types of acts and actions that were being taken by the law enforcement agencies relevant to these 9 acts of serious misconduct. It really did give us a good purview of kind of the totality of discipline that's happening at the agency level. It also made it really hard for us to weed through 22,000 reports. But we're now at the point where we can, at least in some fashion, provide you with statistics that I think are helpful. What are the top 3 allegations? Which you can see there: abuse of force demonstrating bias and abuse of power. And then dishonesty falls in there closely thereafter. How many cases is post working? Post is actually working in post right now, 5,588 cases. So that means that the agency has done their part, they're done with it, and we're actively investigating those cases. That's a ton of cases to investigate. So the agencies are still investigating 4,700 cases right now, where they've done some reporting to post, but they're not finished with it, right? So it's still under their review. Those are likely complaints, charges, and allegations, and not a case that's done deal, finished IA. And if you look at that 5,297 closed cases, the vast majority of those cases closed are those retro non-actionable cases. So that kind of answers that question for you. Are there any questions about the stats? There's roughly a little over 14,000 officers involved in these cases. So that was another statistic the commission asked for at the last meeting.
So I guess my last question pertaining to this would be, so far, has there been any officers actually decertified? And then if so, are we reporting those to the national index,
Yes.
National Decertification Index?
Yes. So there has been officers decertified, it revoked, and that is through, there's two kind of pathways. They've been convicted of a felony. That's an automatic decertification in the state of California. So they are reported to the NDI, the National Decertification Index, and they're posted on our website. We have also had officers that are deemed ineligible, which basically is similar thing. We don't go through and say it's a revocation, but they can't be a peace officer in the state of California. And that's for felonies that occurred prior to January 1st, 2022. Those are also reported to the National Decertification Index. In terms of the revocation proceedings that you guys are involved in, the first board hearing we ever had was December 14th, and you adjudicated 2 cases. Those are the first 2 decertification cases that are working through the procedural steps. So we are just now at that phase of, now it goes to the commission, and then the officer, if they appeal it, goes to an administrative law judge for an evidentiary hearing. But there's been decertification efforts on the part of the felony convictions. There's also been surrenders, where the officer said, I don't want any part of this. I'm going to voluntarily surrender my decertification or my certification, excuse me. And Mike Radford's going to talk a little bit about that as well. Questions about statistics, anyone? Okay. All right, I'm going to invite Mike up, and he's going to talk to you a little bit about what we do internally on the investigative side. And then we're going to move into where you folks get involved and we start talking about the hearings.
Good morning. Yes, my name is Mike Radford. I'm the Bureau Chief for Los Angeles County, geographically the smallest, but got more than all my other guys. So my job today will just be to talk about, once these cases come into post, what is that process, the mechanism of which the POSAAB team receives, processes, and eventually brings for your review. So obviously there's a few ways that misconduct cases come into post. They are all brought into our Intake and Disposition Bureau through means of either a citizen complaint. We do have a mechanism where a citizen can put a straight complaint directly in. And obviously from an agency, once they have discovered that there is some level of misconduct, obviously they have 10 days to report to us. And that is that's coming in 2 different ways. One will be through an open complaint. An agency initially gets the report. They have those 10 days and they give us a very basic, hey, we've got information either through our own citizen complaint process or our internal review of some sort of misconduct, and they've reported to us, letting us know that they're working on that case. Or there is times when a case can come in and it's completely completed. So we may have those that are actually completed. So it's reported to post either by agency or through a citizen complaint. So once we get it in, the disciplinary investigation process can start. If it's an open complaint, by process, we just allow the agency to conduct their investigation, right? Post does have the ability to do an investigation, but the majority of the time, we just return it right back, or we just wait for that agency to complete their investigation. We have timelines in which we reach out. We try to ask for 90-day updates to continuously keep apprised of what is going on with these cases. But again, these agencies may have lots of things that they're dealing with. They may be tolling for criminal or all sorts of other items. So we do attempt to try to keep up and keep an eye on where these cases are moving. When they do come in, we try to give some sort of priority. There's, as you see with 15,000 cases, it's important for us to try to have some sort of identification which some of these cases are extremely important for us to work on immediately or to watch, and so on. So through intake, we've kind of put together a process in which we give a level of priority. And we give a priority of either 1 through 4. Very basic, anything that's sustained, we give it a priority of 1. So the bureau chiefs and the admin team can kind of take a look at it. If it's a not sustained case, an agency has found it to be unfounded, frivolous, demonstrably false, we give it a priority 3, and we identify it that way. Priority 4 is where what Brian had talked about would be the non-action retroactive cases. regardless of their findings, we don't even have the jurisdiction to take action on it. And we reserve the right to label a case a priority 2. That may be a sustained case, but it may be very low level. It could be just nothing more than a agency policy that has been violated and more than likely will not result in any action on our end, though we still put our eyes on all of these cases at some point. So moving through the post-investigative process, once they all return to us, we'll again receive them. We identify what agency they go to, and we conduct any type of investigation that might fill in a gap. Sometimes these internal affairs reports, they rise to their own level of preponderance of evidence. And of course, we have to go to what we deem as a clear and convincing. So at times we may find ourselves in a position where we do need to do further investigation, but most of the time the reports are very well documented. So we bring them in and we begin the process of identifying enough evidence that we could identify if it is clear and convincing to one of the serious misconducts that we can move forward with. So with 4 different bureaus, it is important that we all try to remain consistent together. So before a case even moves forward to what we feel is a decertification process, one of the internal processes we have is we do what we call a bureau chief peer review. So if a case comes in and a law enforcement consultant says, hey, I think this is a case that we're going to want to move forward on, more than likely we'll bring it together with a minimum of 3 of the bureau chiefs, and we'll even bring another bureau chief from outside of post. And we present it, we look at the facts, and we say, is this a case, if we can rise to clear and convincing, that we feel would be decertifiable and we should move forward to the executive office for review and eventually to the board and the commission. So we try to maintain consistency through all of our bureaus, even though we each individually have the responsibility to investigate that case.
So I know Post has created the division, but when you say bureau, who are we referring to?
As described in our organizational chart, POSAAB, the Peace Officer Standards and Accountability Division, is broken into different bureaus.
Okay,
Right.
got it now.
And in the state has been broken into the 4 different bureaus: Northern, Central, Los Angeles County, and Southern. So each one of us, we receive the reports from those individual agencies in that jurisdiction. Correct.
Mike, has there been any discussion about occasionally talking about cases where someone has thought they should not be decertified?
As far as someone in either the LEC or
So when you meet for the bureau, is the various bureau chiefs get together and discuss a case that there is a recommendation for decertification,
yes,
and you get your colleagues' thoughts about that? Has there been any discussion about occasionally bringing up a case where the resulting opinion was not to decertify, to see if people are on the same board, place?
absolutely.
Yeah.
As a process, it wouldn't probably make much sense to have a panel if every case was just locked and
Right,
just
right.
move through. But the reason why we have that panel is because a lot of the cases that we bring to that peer review table are cases that may or may not rise to an egregious level, depending on who might be looking at it. So we try to get together as a collective group, using our training, our experience. We bring in, like I said, a BC from outside of POSAAB. We even bring in another from maybe downstairs or somewhere else that has some level of experience in law enforcement. And we'll debate, we'll bring it together, we'll look at the evidence that was collected from the agency and determine if it is a case that could, if it rose to that clear and convincing level, would it be egregious to the point where we should move it to the executive team to give them their decision?
So peer review isn't only for cases where the opinion of that particular bureau chief was the person should be decertified. It's it's cases that are questionable as well.
Correct.
Okay.
I don't have stat.
I don't need the stat. I just
but
want to make sure that avenue is also available.
There's absolutely been cases
Okay, thank
where we
you.
have decided not to move forward with these. So once the post team does determine that this is a decertifiable case to move forward, the law enforcement consultant will move to write his report or her report, the investigative summary of findings, which details the clear and convincing evidence that they have found, and we move it forward eventually to the executive team. The executive team is presented with the case, them as well as legal. Our legal team look to see if it does meet that clear and convincing. Is it an egregious misconduct based off the 9, and should it move forward to the board? And those that have been determined yes to move forward, we begin the process of the intent to decertification. If serious misconduct is not determined, or we don't rise at that clear and convincing, we may return it back to the LEC for more investigation, or we may just close it and say, nope, it does not rise to that level and it could be closed at that point. Once the determination that we have met our clear and convincing level, we do send out a notification to the, and I'll back up, I apologize, I did miss. Once we do determine that we have a priority 1 case and we are going to start the investigative process, we make several notifications out to the officer just to keep them apprised. We do a notice of investigation, letting them know that a case has been reported to us. We are going to begin the process of investigating a case of possible misconduct, giving them information as to what that process is about in a contact, though they may want to, obviously there's probably lots of concern on their end, so we give them that information. Yes.
Just to get some clarification, you just used the term egregious, and my recollection is that that's the standard for acts that violate the law, but that's not necessarily the standard for other categories of misconduct. I just want to be sure we're talking about serious misconduct, not necessarily egregious.
Correct. Thank you. So jumping forward to the, after the executive team has determined, yes, we do agree, this is a clear and convincing case of misconduct, we also send out a notice to the peace officer with the intent to decertify. This is the notification we send with proof of service because it's very important. There are timelines that are required by law that we give to that officer. They have 30 calendar days. We give them 30 calendar days to respond back, stating they wish to participate in their due process, at which time we can start the process of preparing for the board. If we do not hear from them in those 30 calendar days, their case will be closed, they are decertified, and we move forward to enacting that process of identifying them in EDI, notifying through to NDI as well. So we wait. Those that have respond, we've already brought a few to the board. Some will now be coming to the commission. Each one of those cases, that officer responded back with their intent to enact their due process. So again, as I stated, if they do not request a review, decertification starts without any further proceedings. Once we go to the board, obviously, board makes their recommendation. Each time that our LAC team will come and we will present the facts, answer any questions. Once the board makes their determination and recommendation, it may or may not, depending on their recommendation, go to the commission. Again, we will come to the commission. We will, as explained by the team, we'll give you the presentation of the case. The officer will have their opportunity also as well to speak to you. And by a 2/3 vote, you'll make your decision whether to move this case forward as well. So as it moves its way forward, from commission, it will go to the administrative law courts. From there, it comes back to the commission. Anytime no further action is taken unless more investigation is needed. And finally, the commission moves to accept or reject the decision of the administrative law judge. And then the commission obviously makes the final decision and required notifications are made. And again, whatever decision is final post processes that through our Certificates Bureau, making all the proper notifications, identifications through EDI and NDI. Any questions on our post process?
Yes. So the Bureau or the Commission recommends that decertification should take place. It comes to the board. The board agrees that decertification should take place. Then goes to the post.
To the
Post
commission, yes.
agrees that it should be decertified. Then it goes to an administrative judge and the administrative judge overturns it. What happens then?
So I think just to make it clear, division makes the recommendation to the board, division meaning us, POSAAB, yeah, to you guys. Let's say you guys say with like last two cases, we move for decertification, goes to the commission, and then legal's going to go into great depth about kind of the stages of the hearing process. The commission says, there's enough there, there's probable cause. There's enough there, we want to see this case move forward for a full evidentiary hearing. Goes before an administrative law judge. That's when they put on their witnesses. That's when they bring their subject matter experts. It's a full hearing. If the judge renders a recommendation, it's not a decision, it's a recommended decision, I guess, to the commission, says, I don't think this officer should be decertified. The commission has options. They can accept that. They can reject that. They can take the case on their own accord and hear it themselves. They can make modifications to the decision. So they have various options once that judge issues a proposed decision to the commission. And today you're going to hear what those options are and maybe how to effectuate that. So you'll go into great detail. The only thing I want to bring up with this process that I think is really important, and we're now experiencing this, is with those letters of investigation. The commission, this is new to you guys too, that we send an officer a letter of investigation that says, hey, we're investigating this officer. We are now getting responses from those letters where officers are saying, I want to surrender. I don't have a desire to continue in the law enforcement profession. I'm going to surrender my certification. We are also in that letter asking the officer, are there any statements you care to make on your own behalf regarding this matter? And it can be informally, but it gives them an opportunity. Let's say they didn't participate in the IA because they resigned. It gives them an opportunity to have a conversation with our law enforcement consultant, which will be documented and recorded. That's part of the case that will be brought before, depending on if the facts are relevant to the findings, brought before the board and the commission. So that's a newer procedure that we've implemented. One, it gives the officer advance notice and they really appreciate it. The other thing it does is it gives the officer an opportunity to tell Post what he or she wants Post to know about the facts of the case. And we don't always get their statements.
Thank you, Marie. Any other questions of the post process that I can answer or help? Yes.
Are there instances where there is a voluntary resignation and relinquishment of certification to where the person, after a period of time, gets it back?
So right now, there is no reinstatement of a peace officer certification like there are in other professions, where whether they relinquish it and they surrender it or they're revoked, that they can come back and petition the state of California for reinstatement. Other professions, absolutely. But right now, there are no provisions for reinstatement in the state of California.
I want to state for the record that my understanding of this process is that the sole function of this board is to review cases where a decertification has been recommended by the division and the officer has appealed within the 30 days. And that means that the only effect that we can have is to, if anything, reduce the number of officers who are decertified relative to what would happen if we didn't exist. And I'm not confident that that's consistent with the legislative intent of SB2. So I want to put that on the record. Hope we can have some discussion around that and see if there is a more expansive role for this board that would potentially enable us to weigh in at other stages of the process so that we can have a greater effect.
That's a great segue into what we're going to get into in phase 2 of this training, but we will talk a lot about the board's governance role, the intent, and what cases you are seeing, which are not just decertification cases. So there may be suspension cases that you're seeing. So your role is to decide whether or not it's appropriate to impose discipline in a case. And we'll talk about the cases you're not seeing, and in particular, what role can the board have, if any, on those cases that don't make it. And if the officer does not appeal and does not invoke their due process rights, it's considered what's called a default, which is they said, I don't want to participate. Whatever the discipline is that was recommended by the division will now be enacted. So that discipline may be a revocation or decertification, or it may be a suspension with a term. If they decide they don't want to participate, then that discipline is in fact enacted, whatever that may be. But yeah, thank you for that. And I think if there, Mike, did you, oh, I think you have another slide, Mike. No? Who's conducting our investigations? Is that you?
Start from scratch. Post-law enforcement consultants have been brought in to conduct all of the investigations that are submitted to post. Law enforcement consultants all have prior law enforcement experience. We look very hard as far as their experience, not only in law enforcement in general, but also in internal affair investigations, personnel investigations. So you can see the most average years of experience are 20+ years of anyone working in that position. Prior internal affair experience or criminal investigative experience is very much, I wouldn't say required, but very much something that is needed. We prefer a lot of investigative experience really is needed to be able to pick out and find a lot of what we need as far as evidence to rise to the clear and convincing that's required. And the majority do come from city, county, state, and even federal agencies. So we look for that experience in all areas. So again, we from municipalities, from counties, former FBI, state DOJ. So we utilize all of that experience in the POSAAB investigative team. That was it. There we go.
Thank you, Mike. Okay, I promised you guys a break about 10 minutes ago. So we're going to take a 15-minute break. And then why don't we just come back right at 11? That way we can resume training up through lunch. Thank you. Okay, let me know when we're good to go. Okay, perfect. All right, thank you guys. We're gonna go until 1 and then we're gonna be breaking for an hour lunch. So you've got to endure this until, oh, is it 12? What time is it? 11? I'm sorry. What time are we going until before lunch? Are we taking lunch at 12 or are we teaching? It'll be ready at 12. Okay.
You just gave me heart palpitations.
I know, I'm sorry. I'm looking for Sarah. Are we okay for 12? Okay, we're okay till 12. I'm sorry, I have people because I don't know what I'm doing. Clearly. So we're now at the phase of training where we're going to talk about the decertification process. I'm going to turn it over to William Toby Darden. Toby, as we fondly know him. And Toby's going to walk you through this process. Again, there's a lot of legalese in this. But our goal is to try to break this down for you so you understand why it was set up this way and how to avoid potential conflicts at the end. Once we get through this decertification process, there's something that I want to speak to that Dr. Glazer brought up at the very end of our last session, and that is the board's involvement in cases that don't come before the board. And there may be an opportunity for some further insight, and that comes in the form of auditing, and that's auditing of closed cases. It's not uncommon for boards, governance boards, to audit a portion of closed cases, and typically it's a random sampling. You don't handpick certain cases because, again, it's supposed to be an equitable review. And then you can assign a couple of board members, not the entire board, because obviously then you're holding a public meeting, and then you'll have the entire state of California auditing closed cases. So that is an opportunity for the board to consider administratively, and that's something that we will work with the board down the line so that you do feel like you have a fair understanding of the cases that aren't coming before you and why they're not coming before you. And I just mentioned this because I want to make sure that we understand there's a balanced approach to this. And as much as the board members cannot become part of the division, because obviously you serve a separate role for a reason, you're not the investigators. I'm not the investigator. So there's all these stages that are built in to kind of protect the integrity of the decisions as they're made throughout the process. It also feels very much like a lot of these things happen in a vacuum, right? Because it's, well, if I don't see this stage, then how do I know it ever made it to this stage or why it never made it to this stage? And I know that those questions are going to continue to swirl, and they should. But there's also a reason why the commissioners aren't investigating the cases and why the board members aren't investigating the cases and the division is, because we don't get to actually make decisions. We just get to, well, in some ways we do. We make decisions about whether the investigative findings reach the level of clear and convincing evidence. So those are the decisions we're making. But again, I wanted to speak to that so we didn't miss the opportunity to address that, Dr. Glazer, because I think it's an important aspect of this process that needs to be vetted. And then I'll turn it over to Toby. Thank you.
Thank you. And Anne Marie told me that I need to make this light and entertaining. So as a lawyer, I may be fired by the end of the day, but I'll try. I also was happy to hear Board Member Glazer's comments because I think it's a good sort of a starting point for us in terms of this discussion of what is this decertification process. And what you raised about whether or not the board's role is consistent with legislative intent was very interesting to me as a lawyer, because we deal with legislative interpretation and intent all the time. And when Senate Bill 2 made it through the legislative process, and I have on occasion had a little bit of involvement in the sausage making that results in laws in California. And so sometimes the bill that may come out of the final part of the process may not be what everyone thought or intended that it might be. But what our job was, once Senate Bill 2 was passed, was to look at the text of the law and try to determine, consistent with the text of the law and legal principles in California about taking away somebody's right to practice a profession, how can we implement this in a way that is consistent with legislative intent and consistent with the statute? The first place that a lawyer starts when you're looking at legislative intent is the statute, the plain wording of the statute. And that's what we're going to do as we go through this today. But again, in a light and entertaining way. Okay, so some of you are new, and this may be new material. Some of you have heard it before. I'm not going to plow entirely old ground, but we are going to do sort of a high-level overview of some of these principles that some of you may have heard before. And at least for me, repetition is a good thing. Okay, so one thing that I want us to keep in mind, and it's actually really important, particularly in light of Board Member Glazer and some of the other concerns that I've had, is the various stages in the process and the role of the board and the commission at these various stages in the process. And it's really important to understand sort of what the legislature gave us and why we interpret these provisions in the way we do in light of the due process concerns that exist in California state law. Stage 1, stage 2, and stage 3, does that come from the statute? No, I made it up, but I think it's accurate because I think it accurately describes the various stages of the process that Senate Bill 2 has set up. So the first stage is the stage 1 hearings are these initial hearings before the board and the commission. And as we'll talk about, that really is just an opportunity for the board and the commission to act as a double check to decide if in fact a case should move forward to a full due process hearing. And we'll talk about the particular penal code sections and why that is. But effectively what the legislature did is it gave the board and the commission a seat at the internal table at post to decide if a case should go forward by means of an accusation and a full administrative hearing before an administrative law judge. It's important to keep in mind, many statutes in California, stage 1 doesn't exist the way it does in Senate Bill 2. So in many licensing, and Anne Marie can speak to this, she's had experience at a number of state agencies that do licensing. Sarah can as well. And that is the stage 1 is something that is likely, and I'll probably say this wrong, Anne Marie, invisible to the ultimate board member or commission that ultimately decides the case. In other words, professional staff at these agencies conduct their investigation, determine that there are sufficient facts that warrant filing an accusation and moving the case forward to an administrative hearing. That administrative hearing occurs, and then the full decision makes it to the board or the commission, and that's the first time that the board or commission has seen it. And the fact that the legislature changed this process and gave you, the board members and the commissioners, a seat at this internal table early on has some important ramifications that we need to consider to make sure that the whole process comports with due process and that we're fair to the officer at the other end of the proceeding after the decision has been received and there's an actual decision made as to whether or not the individual's license should be revoked. So that's stage 1. Stage 2 then is that full administrative hearing before an administrative law judge, and we'll talk about that in some detail. And then stage 3 is the stage where the decision of the administrative law judge has been now brought back to the commission. And the commission now, looking at that record, the ALJ's proposed decision and whatever exhibits or attachments are included, and then the commission gets the chance, based on that full record that happened at the hearing, to adopt or non-adopt or modify the decision. And we will talk about those options. Now, one thing that this will either be good news if you don't like me, and bad news for those who for whom I have been the commission's counsel for many years. There's a due process concern with me being the lawyer advising the board or the commission in its what we call adjudicatory capacity. So I always have been the lawyer for the commission for all purposes. But now Senate Bill 2 has given you, the commissioners and the board, a new function. And that is a function effectively to act as judges to decide based on facts and based on law whether or not an action should be taken. Now, the law says that because, and we may be able to modify this in the future, but at least as it exists currently, I, as the lawyer for Post and my team, which is a relatively small legal team, we are involved in those prosecution aspects of the case. And because of that, it's not fair for me, as I'm talking to the prosecution side of the House, to then be able to come in and represent you, particularly in closed session, to advise you as to whether or not you should be doing the very thing which I have been perhaps advising POSAAB with respect to how to handle a particular prosecution. So because of that, the law sets forth some pretty clear delineations from a due process perspective of the role of legal counsel. And so because of that, we've reached out to the Attorney General's office, and the Attorney General's office has agreed to provide counsel for the board and the commission in their adjudicatory capacity. And that is Chris Beatty, if you want to stand up. Chris Beatty is a Deputy Attorney General. I worked with him for many years in the Oakland office when I was at DOJ. And Chris is going to serve the role as board counsel and commission counsel on these adjudicatory matters. And how we sort of walk this due process line is Chris is not involved at all in the prosecution of the cases, in the looking at the cases, in advising POSAAB on any of the legal issues and making the determination as to whether or not those cases go forward. So we are putting up effectively an ethical wall. So he has no involvement in that process. And so if the board has questions or the commission has questions to ask of counsel, and they want counsel to advise them in their capacity as judges, their adjudicatory capacity, then Chris will be here and will be able to advise you in that capacity. But I thought I would address that issue so you understood why all of a sudden at a commission meeting, I might get up and walk away and another lawyer may come in, and that's going to be why. Okay. So let's go in a little bit more detail into the proceeding. Stage one, what is the stage one proceeding? Well, it's an opportunity for the board and ultimately the commission, although the role's a little bit different for the commission, to receive the division's findings of its investigation and to decide if it's the kind of case that should move forward to a full hearing before an ALJ who's going to hear all the evidence, consider all the legal arguments, and render a proposed decision. Remember, the stage one proceeding is not a trial. It's not an instance where discovery is allowed or cross-examination or presentation of defenses. It's just an opportunity, and this is laid out in the statute, and I'll put it up in a second to show I'm not making that part up, that it's just an opportunity to hear the division's findings of its investigation and decide if it is the kind of case that should move forward. And if there's a question about due process, is it fair to handle this stage one proceeding this way? The answer is yes. And the reason is that the legislature has set it up in this way so that, again, at stage one, it's really just a seat at the internal table to decide whether or not the division has found enough facts in its review of the investigation to warrant moving the case forward for a full administrative hearing. In an example, I've been a civil lawyer for longer than I want to admit publicly. And because of that, I'm familiar with sort of what happens in civil lawsuits. And in civil lawsuits, a lawyer will do an investigation, hopefully, and believe that the lawyer can prove certain facts. And they'll draw up a thing called a complaint, and they'll file the complaint in court. And that the trial doesn't happen for many years. At some point, the judge may be asked to look at this complaint and decide if, just looking at what is stated in the complaint, if those facts, if they're proven to be true, does that actually amount to a legal claim? And judges do this all the time in civil cases without making a decision ultimately on the merits of the case. And if that's you, let's think about it. If you're sued by somebody and you get served with a complaint and you want to go to the judge and say, Judge, look at this complaint, it doesn't cut it. Even if everything they say is true in this complaint, it doesn't amount to a claim against me. And you want the judge to be able to look at it and make that decision. Yes, I agree with you, or no. Now, they may not be able to prove it. And ultimately, when you get to trial, there may be a whole different set of facts that are ultimately proven before a jury. But if it is proven, then it would amount to a claim against you. And it's something similar to that here. So we don't file civil complaints, we file something called an accusation. But the accusation does effectively the same thing. It is just an instance where we have made a determination that we believe that we can prove facts ultimately at a hearing and that those facts amount to a reason to bring discipline against the licensee. And in our licensing scheme, that means that the person engaged, the officer engaged in serious misconduct. Now, in licensing cases in California, the law has been the case for quite some time. that for professional licenses, the burden of proof is clear and convincing evidence. And you'll hear a presentation by one of my lawyers a little bit later in the day about clear and convincing evidence, but it's a standard that's been well understood in the licensing context, that to take away someone's right to engage in a profession, clear and convincing evidence has to be proven. So really the first stage, stage one of this proceeding, is the division is going to present to you those facts that the division believes can be proven at this hearing and that they believe established by clear and convincing evidence that serious misconduct can be proven. Now, to show you again, I'm not making it up, let's look at the actual statute. Statute tells us what the board's duties and obligations are. And it says the board shall review the findings of investigations presented by the division pursuant to the earlier paragraph and make a recommendation on what action should be taken on the certification of the peace officer involved. So what you get, the findings of investigations, is you get this document, and we've already had our first board hearing. The board has seen it, and the commission will see it when we come up on the commission meeting. The document's called the ISF. It's the Investigative Summary and Findings. And this is where the division has done the hard work of going through these thousands of pages. And, you know, law enforcement professionals, you've seen these internal affair investigations, and you know they can be very, very lengthy. And you can have thousands of pages. I've even seen some that are close to 10,000 pages in terms of all the attachments and exhibits and transcripts and all of that stuff. So the division has done the hard work of going through all that material and putting together for you the ISF, the Investigative Summary and Finding, which explains that they have reasonable grounds to find that discipline should be taken against this officer for serious misconduct. And remember, I said clear and convincing evidence has been the statute that's largely been required in California for a long time in professional licensing cases. And that's why you see this language in 13.510.85A4, where the board can only recommend revocation of the officer certification if the factual basis has been set forth by clear and convincing evidence. And like I say, you'll get this discussion about that a little bit later, but it basically means, does the evidence, if proven, if we can prove it, and it's found to be true, does that establish a high probability that this serious misconduct occurred? So the division might say, for instance, that there's a sexual assault claim, let's just say, and they come before you with a statement of a victim, with perhaps video evidence, with witness statements, and maybe an officer's admission. And then the question is going to be, if they present that to you, you look at it, would you conclude, looking at all that evidence, that there is a high probability that sexual assault in violation of the statute occurred? But this brings us to an important caveat that's important to understand, and that's a little confusing in light of the clear and convincing evidence requirement in the statute. It's very important that we not make judgments, final judgments at this stage one, about whether or not the misconduct in fact occurred or whether or not discipline is actually warranted or not. Why is that? Simple. Let's go back to the example that I gave you in a civil case. You've been sued. You ask the judge to look at the complaint to see if the complaint states facts, which, if true, are sufficient to warrant a cause of action against you. The judge looks at it. What you don't want the judge to do at that early stage is to say, you know what, I've seen enough. We don't need a trial. I've decided that you're guilty. You are going to be found liable of this, and I don't care what happens at trial. Obviously, you don't want that to happen. That's not fair. That's not consistent with due process. So the judge, if the judge looks at a complaint early on just to see, is there enough, if this is true, does it amount to a claim? You don't want the judge to then take the next step and decide you are guilty. You want the judge to have a fair mind when you ultimately get to trial. And at the trial, in this case, the officer can come forward and say, you cannot believe this witness is lying, or this evidence you were not presented with, or I have a technical legal defense, which you did not hear and you need to hear now. That's what trials are for. In the civil context, you have juries or sometimes judges that sit as finders of fact. Well, it's the same thing here. So because of that principle, again, because of due process, it's very important that at this early stage, stage one, you are really only looking at if it is true, if it is proven to be true, is that enough? Does it amount to serious misconduct in violation of one of our statutes? And if so, would it amount to a cause for a revocation or suspension of an officer's license? And that's all that really can be determined consistent with due process principles. Because at stage one, again, the board and the commission don't hear from witnesses. They don't decide disputed facts. The officer doesn't put on their defense. The officer doesn't provide evidence, additional facts, or legal briefing. And we'll talk about what the hearing looks like. And under one of our regulations, during public comment, the officer will address the question, and really a limited argument that the officer is allowed to make at this early stage. And that is, do the division's findings, if they're true, is it sufficient to establish serious misconduct under the penal code and under our regulation? And there may be some mitigation evidence that comes out under 1213 if it's apparent from the facts set forth in the IA or in the division's findings, but you're not going to hear all of it. So again, this is not a full trial. And because of that, you need to reserve judgment, just like you want the court to reserve judgment on the ultimate question of, well, wait a minute, after we do hear all of that stuff, all of the witnesses come in, credibility is decided, all the legal defenses are put in, additional evidence and witnesses are put in, that's when a judgment can be made as to whether serious misconduct actually did occur and whether or not revocation is warranted. So just as you would want that to be the case if you were a civil litigant, we want that to be the case here for the officers. Okay, now let's look at the commission's statutory basis for the commission's duties. Now this, again, it's not intuitive. This is a process, Board Member Glazer, of the legislation. This is what the legislature gave us. What does the commission do? Stage one, we're still at stage one. The commission does not redo the hearing that just happened before the board. There wouldn't be any reason for there to be a hearing and then a complete redo of the hearing. So the legislature has said very specifically what the commission's job is. Again, stage one, at stage one. The commission is to review the recommendations made by the board. And if the commission is deciding to adopt a recommendation to seek revocation, it requires a 2/3 vote of commissioners present and shall be based on whether the record in its entirety supports the board's conclusion that serious misconduct has been established by clear and convincing evidence. Whether the record in its entirety supports the board's conclusion. So that tells you that what the commission is doing is different from what the board is doing. The board establishes the record. And Board Member Glazer, to the extent that this may help, it's very important what the board does, because the board establishes the record that then goes to the commission in terms of the determination as to whether or not the case does move forward for revocation or not. So the extent that the record is fleshed out and fully lays that out, that's what the commission reviews. Yes. Okay, Rick, I think you had your hand up first, and then we'll go to.
Real quick, since it's not a hearing, and not all the facts are presented to the board, is the board merely recommending that a revocation or a suspension is warranted and not recommending either one? It's just this moves forward for suspension or revocation.
Good, a very good question. So let me explain. So when the division prepares the ISF, the investigative summary and findings, the division makes a recommendation in that ISF, and it has to. And the reason it has to is that if the officer does not appeal, we have to have something to then implement. So in other words, if you don't appeal, the division's recommendation is implemented. If there wasn't a recommendation, then we would have nothing to implement. So long lawyerly way of saying, sorry, Anne-Marie, long lawyerly way of saying the division will recommend, for instance, revocation. Now it goes to the board. The board's job is to make a recommendation to the commission, okay, based on the factual record. If it comes to the board as a revocation, recommendation from the division, the board has every right to look at it and say, we disagree. We don't believe that this is a case which proves serious misconduct by clear and convincing evidence. Nothing should move forward. Or the board might say, we do agree that this is there is serious misconduct and it is a revocation case. Or the board might say, we've looked at it. Thank you for your recommendation, division, but we do not believe this is a revocation case. We believe this is a case where a suspension is warranted. So the board is making that revocation, and it is that factual record which is then presented to the commission for the commission to determine what action to take based on that factual recommendation. Yes, I'm sorry, yes. Apologies.
The, where it says shall be based on whether the record in its entirety.
Yes.
Does the fact that the legislature put in there in its entirety allow the commission to expand the record at that time beyond what the board looked at?
Very good question. So in just looking at the wording of the legislation says that the commission's determination is based on the record before the board. Now, the lawyers, we can argue because the legislature only talked about a decision to adopt a recommendation to seek a revocation and a 2/3 vote, and it may be something different if there's a different, and we'll get to that if we need to. But so the bottom line is when the commission reviews it, the commission is not establishing a new factual record. So the commission should not be, so in other words, the officer should not get up during public comment and say, well, the board didn't consider this. I want to tender this declaration, or I want to tender this fact. That's not what the legislature has contemplated. So again, the commission's review is restricted to looking at whether or not the record supports the board's conclusion that serious misconduct was established by clear and convincing. Yeah, go ahead, Rick.
And Toby, if we don't think the record is satisfactory in its entirety, we would then kick it back to the board. Is that correct? Send it back to the board by vote?
Yeah, actually, it would be sent back, at that stage, it would be sent back to the division. Anne Marie, do you have a different thought on that?
So, Rick, I think it depends if what your question is let's say the board has made a recommendation to the commission to revoke. You review the record of the board, which will include the subject officer statements or their attorney statements at the board hearing and the transcripts of that hearing. At the review by the commission, you determine there's not enough here for us to make a sound decision about moving this case forward. Is that your question? That it would be returned to the division for further investigation?
Or does it back up?
Questionable.
Sorry, I didn't push the button. Back from the board back through, or does it go back to the division, then straight back to the commission, I guess? That's the question.
I guess that would depend on if we brought new information forward, would that warrant a new board review? It might. If there's no new information that we're able to gather based on that case, right? There's just nothing more that's really based on the division's findings. Then arguably it wouldn't go back to the board because they've already assessed the facts and they've already made their recommendation. If new facts are presented, it may in fact mitigate what occurred before the board. Arguably, we'd want to bring that back for the board just to make sure that it's a complete review of those facts.
Because I guess the question is, because then it would change the entirety, because right now it says the entirety of what went to the board first.
Correct.
If you brought
Right.
new facts back to the commission, we
Go back.
did an end run around the board. So that was just the question I had.
Yep,
Yeah.
I think that's, Anne Marie's got it exactly right.
Okay.
Yes, go ahead.
And so what was the legislature's purpose in establishing the stage 1 board review?
Very good question. And I was not personally involved in all of the negotiations that went back and forth between the various interest groups, but I know that there were various interest groups. I do know that there were various interest groups that were advocating for various things to be added into the legislation. So
Why?
Why? Well, I mean, you know, I guess you'd have to ask the interest groups. But obviously there are some interest groups that represented you know, ACLU, for instance, Black Lives Matter, that, those groups were interested in seeing it evolve a certain way. And then my guess is that there were also the law enforcement associations, the police chiefs and you know, various associations representing sworn law enforcement officers and probably agencies. I shouldn't get too far because I haven't, let me put it this way. I pulled up the legislative history for SB2 and the letters that were received in support and in opposition to it, it was probably this thick in the record. So there certainly was a lot of input from various folks. Why it ultimately ended up the way it did, or why a provision was put in or taken out, or what the intent was, it's a hard thing for us to try to figure out. And the problem is, as lawyers, I'm just telling you what happens is when a lawyer looks at this, we have to follow a very sort of a strict way of looking at it. What's the
And
plain language? Right.
And I'm not asking
Yeah.
that question.
Okay.
I'm asking the cut to the chase.
Right.
If you ask you know, Bradford, what would he say?
Well,
That's the
boy,
question.
I certainly cannot speak for Bradford, and wouldn't try. So I honestly, I can't.
Yeah.
You'd have to ask Bradford.
Okay.
Yes, go ahead.
So I would say from the NAACP who supported SB2, along with Bradford, was the initial point of bringing together a board was to bring transparency. The community is calling for transparency. They wanted to also be, because there are a lot of times that what we were seeing was that officers' misconducts kind of went under the board. No one ever heard about it. No one ever got to see exactly what was the process. And so I would say I'm only speaking for the NACP, I can't speak for anyone else, is that, and I serve in a California state NACP too, was that it was a call for transparency and having a board that would provide community input and to be able to see a process that now the community can say, kind of like a touch feel type of thing, we're seeing this process instead of in the past, we didn't see anything.
Okay.
All right, yeah, if I can add. I was a part of the coalition, so to speak, as co-sponsors also to getting this bill passed. And of course, what we initially wanted was contested by the police unions and lawyers and what have you. So there was manipulation and this pulled out and that put in to finally get something that we both agreed to that came into existence. So that was the whole, and we spent many of Mondays, every Monday, for about almost 2 years getting to this.
Right. No, and that is exactly what I would have expected if, and that is the bottom line is, there are various interest groups that wanted certain provisions put in, and the final bill came out was a bill that could get through the legislature, and you know, maybe it was one of those things where everybody was a little unhappy, or not. I don't know. But the bottom line is, it kind of is what it is. And so for us, we have to look at what does the plain language of the bill tell us? And then if there's some question as to plain language, then we have certain rules that we looked at in terms of how we can try to understand the legislative intent to the extent that it's possible, but we do that through sort of lawyerly ways of looking at language in other parts of the statute and other sorts of principles of law. So unfortunately, and I'll say this, and then I'll get off my lawyer soapbox because it's probably neither entertaining nor what was the other word, fun. But believe it or not, courts, if we could get a declaration from Senator Bradford, that would have very limited utility in a court, because a court will say it's really not any one person, even the author's understanding in terms of how a law ultimately will be interpreted. the court will look at what's called the collegial intent of the legislature as a whole, or what was the intent of the legislature in passing the ultimate bill. So I wish I had better answers for you. I don't. And so all we can do is just interpret it as best as we can, which is what we're trying to do here. So, yes.
I think it's important for the commission to understand that what they're not going to see in the record are the deliberations of the board. Okay. So what happens during the process is the board thus far has removed itself, gone into a private room and deliberated the issues in the case. So if you're in a position where you're saying, well, what was the board thinking when they said this? You're not going to see the deliberations. And you can comment on that or not, but it's just not part of the record.
Yes, and in fact, I am gonna talk about that in just a moment. So real quickly, again, stage one, and I want to go through this pretty quickly so we can get into the other stages. What determinations is the board making? Based on the information the division presents in the ISF, if the division's allegations are proven at this later hearing and without more, is it highly probable that serious misconduct as defined by law and regulation occurred? And if so, what kind of discipline does the board recommend? And for the board, it's a majority vote that moves the recommendation to the commission. What determinations is the commission making? Commission's determination: did the record before the board establish that it's the kind of case that falls within a serious misconduct category, and was sufficient evidence found by the division such that the case should be moved forward to the full evidentiary hearing to determine the full facts and consider whether discipline should be imposed? And if so, the commission returns any decision that the commission makes to require action against the officer back to the division. The division then initiates proceedings before the Office of Administrative Hearings to initiate the proceedings for a formal hearing before an ALJ. Okay, so what documents are you going to see? Again, stage one, it's only a charging decision phase. Again, we all know that these pages can be, as I've said, hundreds or maybe thousands of files, and under Bagley-Keene, the problem is anything we present to you in a meeting becomes public, and you're likely aware that all these documents are chock full of highly confidential information that might not be available or appropriate for public release, minor victims, sex assault victims, home addresses, that sort of thing. So the division, again, has done that hard work of sorting through those materials and giving you the facts in the ISF and materials that relate to the issue. And again, the statute says that the division's findings is all that is presented. And so you will be given all of that in the ISF. Stage two is where the more complete record's going to be made. That's the actual full administrative hearing. But again, limits on stage one. Statutory limitations on early disclosure. That's because the statute itself, Senate Bill 2, envisions when material becomes public, and it becomes public when it's presented to the board or to the commission. Obviously, PRA and due process limits on what can be shared until that later stage. Okay. Now, let's talk about what do the hearings look like. Now, we've had our board hearings and the board members have seen them. So the board members know what the board hearings look like. And the commissioners, you will see what the board hearing looked like because you will get that full record. So let me explain. So at the board hearing, and this is, you guys can, fall asleep for a little while because, you guys have got this down. You know what happened at the board hearing, but the commissioner, the commission may not know this. So what happened was our law enforcement consultant comes up, law enforcement consultant presents the case facts and the recommendations to the board. The board can ask questions of the law enforcement consultant. There's then a public comment period. And again, we've laid all this out in our implementing regulations. The public, we can get literally members of the public can come up and comment on this particular case. The officer or the officer's representative may also make a public comment, and the board can ask questions. But again, because of the unique statutory issues with stage one, really the comments and the questions need to be limited to this very narrow issue at stage one, which is, do the facts that the division found and presented to you as facts that they believe could be proven, do those facts make it highly probable that serious misconduct in violation of the law occurred? Everything else is going to be raised at the stage two evidentiary hearing. I say that right, Anne-Marie? Okay. Okay. Yes.
The highly probable standard?
Yes.
Is that in the legislation? Is that, where did that come from?
Very good question, Board Member Glazer. And that fellow right there in the back is going to be giving you some training on the clear and convincing standard. I sort of preempted his training a little bit because clear and convincing, it's generally understood to mean, is it highly probable? And as Bryant will take you through, there are various, levels of proof, right? You can have beyond a reasonable doubt, which is the criminal standard. You can have a preponderance of evidence in the civil case, or you can have this sort of in between clear and convincing evidence, which is more than a preponderance, less than beyond a reasonable doubt. But so, yeah, the highly probable is not in the statute. Clear and convincing is what's in the statute. But that's sort of my way to help you make sense of it, or to help you understand it. So the board can go into closed session to deliberate or to view confidential material that can't be shared publicly. Let's talk about that. So deliberations are permitted under Begley-Keene to be done in closed session. Board doesn't have to. The board can choose to deliberate in open session. It doesn't have to. But sometimes it's a good idea to go into closed session to allow open, free, full exchange of ideas and all of that stuff. So the other reason that it may be necessary for a board to go into closed session is that there are materials which cannot be publicly aired. And there are certain materials that are very graphic, that raise privacy concerns, or there are statutory restrictions on public disclosure. So as much as the interest in Begley-Keene in public dissemination of facts and information is an important one, those are circumstances where the board would have to go into closed session to evaluate that evidence. So that's the reason why a closed session can be held for the board. Then the board reconvenes in open session and decides what the recommendation is that's going to be made. Now, one thing we thought we would mention, and this is completely up to the chair of the board or the commission, and that's how votes will be taken. But one possibility, if the board members or the commissioners are not 100% clear on the fact that, let me say hypothetically, there's a case where perhaps reasonable minds might differ as to whether or not it's a suspension or a revocation case. A vote is made to revoke. Well, sometimes it might be helpful for the board members or the commissioners to know, well, there's somebody else that's going to make a vote. If that one fails, there's somebody else that's going to make a vote to suspend. And so for that reason, one possibility would be, and it's up to the chair again as to how they want to do it, one possibility would be, hey, if somebody wants to make a motion, they make a motion, it's seconded, and then there's debate, and then it's voted up or down right then. Or the chair might decide, well, let's hear for a motion. We get a motion and a second, and then there might even be a question. Okay, before we do that, are there any other motions that would like to be made and seconded? So that then, as you're having the discussion, you would know, I'm kind of thinking, maybe not leaning in favor of revocation. I'm thinking more suspension. So I think I'll wait until that second motion is brought, or maybe I'll vote this one down because then the second motion will be brought. Again, the commission and the board can decide how to do that, but it's just important to keep in mind that as you're voting, if a motion is made to, so let me flip it. It's a case where a lot of folks on the board or the commission would think this is clearly a revocation case, but the first motion that comes up is to suspend. Well, then under the protocol that I just gave you, the chair might decide, okay, we have one to suspend. Is there anybody that would want to bring one to revoke? Or alternatively, hey, there's one on the floor to suspend. It's been made and seconded. Let's argue it. And then if a vote is held and that is voted down and that suspension is not adopted, then you can continue with the next vote. So again, I probably made that way more complicated than I need to, so I'm sorry. Never let a lawyer talk about things like this. I apologize. Anyway, okay. What do the commission hearings look like? So again, the commission hearing at this stage one is not a redo of the board hearing. The commission just reviews the record of what happened at the board to determine if clear and convincing evidence supports a recommendation to revoke, and the commission gets the record before the board. What is that? It means the commission's going to get the board agenda and the attachment before the board, a transcript done by a court reporter of the proceedings before the board. Now, closed session. Your attorney, that fellow right there, Mr. Beatty, your attorney can advise you in closed session of any relevant closed session details from the board hearing. But as Joyce said, the deliberations generally would remain confidential. And so the details of the deliberations would generally not need to be shared. But the commission may need to go into closed session if the board in closed session reviewed graphic material, then the commission would also need to go into closed session to have the opportunity to review that same graphic material, because again, that is part of the record of what happened before the board. Then after the motions are made and seconded, if something is adopted and there is a recommendation order, we will have a written recommendation order that will be signed by the chair. That written recommendation order will go to, will be the ultimate determination. Okay, so the commission hearing, what will happen? So the law enforcement consultant will come up and he will guide the commission through the board proceedings. So the LEC will help you understand what happened before the board. The commission can ask questions of the law enforcement consultant about what happened before the board. Again, there can be public comment with the officer or the representative commenting, and then the commission can ask questions of public commenters. And here, the comments and questions should be limited to the issue of whether or not the record before the board in its entirety supports the board's conclusion that serious misconduct was established by clear and convincing evidence. And I know it's tough, right? It's not intuitive, but it's what the legislature gave us. So we're trying to guide you through it as much as we can. Okay. Then, as we said, the commission can go into closed session to deliberate or view confidential material. Following closed session, the commission reconvenes to make a determination. Again, keep in mind alternative motions. The chair might permit alternative motions, or if one motion fails, then obviously another motion can be brought. And in this case, a 2/3 vote is required of any order to adopt a revocation recommendation. And again, that's just what the legislature required. So it is a majority vote before the board, but it is a 2/3 vote before the commission if it is to adopt a revocation order. Okay. All right. So, wow, that was long on stage one, wasn't it? But man, yes, Rick, go ahead.
I'm going to be the troublemaker here for a second. Stage one
You've
to the
never done
board.
that, Rick.
Never. Stage one, it's at the board. Staff recommends a suspension
Yes.
of 30 days. I assume they're going to recommend a suspension because we're looking at either the bail schedule or matrix, whatever it is, to be consistent. The board decides to modify that,
Right?
which they would do in the same motion type thing. You could take a single motion or multiple motions on
Right.
that.
Absolutely.
Then it comes to the commission.
Yes.
The commission is then free to do, if they choose by 2/3 majority, no, we won't, this needs to actually be a full revocation, not a suspension, correct? Or
Absolutely.
modify any of that along the
Yes.
same process.
Yes.
But
Yes.
the recommendation that what's the term I'm looking for? It's not history. What's the term I'm looking for? The record will reflect the motions unless they're taken in closed session. Is that correct?
Correct.
And so we'll be able to see that record of how some of the motions came through
Yes.
if it's in the public record.
Correct.
Okay, thank you.
I don't think motions are ever taken in closed session.
Right.
You
Yes.
just said, you said motions taken in closed session. No.
Gotcha. No, thank you for that. Yeah.
Ultimately, the motion in terms of whether or not to suspend or revoke would happen in open session.
Yeah,
So
just not the deliberation if it was in closed session on got it. Thank you.
once in a blue moon, you can end up, as you know, we can end up with the vote in closed session, but I don't think that's going to happen here. Okay. Anything on that one, Anne Marie, or?
Just in terms of the record and going into closed session, the board chose to go into closed session for both the cases they heard. And again, that's kind of at the discretion of the board at the time, depending on the facts of the case. In terms of the material, the sensitive material, Toby talked about that could be reviewed in closed session. you as commissioners and the board itself got those materials ahead of the meeting to be prepared for the discussion. So even though we wouldn't show the materials that are sensitive in open session necessarily, they'd be showed in closed session because of the sensitive nature. I just want to make it clear, you're not obligated to review that again. So you've already watched, let's say for this next hearing, you've seen the video, you know what's in it. Now you're reviewing the record itself, and it's time to deliberate on the case. It's an option as to whether you as a group want to go in and watch that video and discuss it, or whether you say, we're good, we've seen it, we know what's there, and we want to just have the opportunity to get some legal advice on the case. Those are things, those are options before you. So I just want to make sure that we don't set up a situation where you feel like you're obligated to go into closed session because there has been sensitive material shared with you as a commission.
Yeah, absolutely right. It's an option. And it may very well be that although everybody says viewed it, somebody says, hey, I'd like us to watch it because I think something happened or didn't happen, which I want to discuss. And so that might be a circumstance where it might be appropriate for it to be decided. Okay. So finally, we're at a stage one, big sigh of relief, and it's noon. Okay. So we'll go through these stages pretty quickly. Stage two is the evidentiary hearing. That is before an administrative law judge. That doesn't happen here before post, okay? There's an option that the commission can choose if it wants to actually hear the cases itself, sit as a court and have an ALJ sitting in there. We wouldn't recommend it. Why? Because these hearings can go days and sometimes weeks. That's why we have an ALJ. So the ALJ, once the case is remanded back to the division, we work with the Attorney General's office. We're required to do this by statute. The statute requires that the Attorney General's office and the licensing section handle these hearings before the administrative law judges. So when the commission kicks it back to the division works with the internal legal staff and with the licensing division, and we prepare this document called an accusation, which is the charging document, just like a civil complaint in a civil lawsuit. The accusation, after it's served, starts this process where ultimately an evidentiary hearing occurs with testimony of witnesses and declarations and objections and defenses and all of that stuff. These hearings are scheduled to happen before the Office of Administrative Hearings in the same geographical area where the officer was employed. So 4 locations throughout the state where OAH has offices, and whatever the jurisdiction that the officer is in, that's where it will be set. Although realistically, I think OAH is going to be doing these as all as video hearings anyway. Okay, just real quick, what does the evidentiary hearing look like? It's similar to a civil trial, but there's no jury. Obviously, the judge makes the determinations. There is the right to call and examine or impeach witnesses, although it is possible for declarations to be lodged in lieu of witness testimony under certain procedures. Evidence and arguments are presented, and evidence is admitted somewhat similar to a civil trial, but with some differences. So the relevancy standard's a little different before OAH, and evidence which is relevant shall be admitted if it's the sort of evidence on which responsible persons are accustomed to relying in the conduct of serious affairs, regardless of the existence of any common law or statutory rule, which might, okay, whatever. So sorry, Anne Marie, I couldn't think of a way to make that entertaining and fun. But so the relevancy standard is a little bit different. Some hearsay evidence is admissible, and generally it's not going to be admissible in civil court unless there's an exception to a hearsay rule. Okay, it's not law school, but hearsay evidence can be admitted in these administrative proceedings if it basically supplements or explains other relevant evidence which is not hearsay. So all of which to say it is a legal proceeding. It does look like a civil trial. Some of the rules are technical and a little bit different, but that is the officer's opportunity for full due process. The officer wants to bring in witnesses to say this was all a setup, it didn't occur. That's where they do it. The officer wants to come in and make a legal argument that his rights under his or her rights under the Peace Officers Bill of Rights Act were infringed and the evidence shouldn't be admitted or the case should be turned up. That's where they get to do it. It's the stage 2. Okay. After the hearing, the ALJ prepares this proposed decision, and they're supposed to do it within 30 days. Sometimes we get it within 30 days. Post is permitted to file it as a public record and serve it on the officer in 30 days. That doesn't always happen, but if that happens, it is not an adoption by the commission of the proposed decision. In other words, the ALJ sends a proposed decision to Post. That then starts a timeline where the commission will then have to get a commission meeting scheduled to evaluate the proposed decision and decide what to do. So let's talk about that. Did you want to say something, Anne Marie?
2 questions for the purposes of everyone hearing them. The first is, are the ALJ hearings open to the public?
Surprisingly, yes.
Okay.
So this is something that is very foreign to those of us who've been in law enforcement, because anything that is a PICHIS type, what law enforcement officers consider a PICHIS protected subject, which is basically peace officer misconduct records. That's something which historically is never done in open session. But again, the law has changed in the last number of years. And so those strict PICHIS protections, where this material was pretty much sacrosanct. And the legislature has made obviously a number of inroads. So now with Senate Bill 1421 and Senate Bill 16, now a number of those records are now no longer PICHIS protected. They're no longer private. And as long as it is a sustained finding on one of the categories that the legislature has set out in what's now 832.7, did I get that right? I think it's 832.7, the Senate Bill 1421. It is now public. That material is public, and agencies, as I'm sure chief executives of the law enforcement agencies know, that material has to be made available to the public. So the statute provides that the proceeding is public. How that will work out, we'll see. Obviously, it's going to be up to the ALJ. But I think, again, if these hearings are going to be done remotely, then presumably it would be a link.
The second question, if the division has deemed something to be highly sensitive and thereby it's being reviewed, it's not for public consumption, it's being reviewed in closed session, can the commission decide to make that public? If the commission wants to reveal that information, do they have the purview to make that public?
So the commission could raise that issue if it was something that it thought needed to be made public. And then that would be a case where it would be a good idea to confer with legal counsel. The problem is there are some pieces of information which in an ideal world, it would be great if they could be out there, but there may be a compelling or a good reason not to. So a classic example would be, for instance, a victim who has requested confidentiality, a sex assault victim or domestic violence victim, or someone's home address. You know, that information, if made public, would be very problematic and could potentially violate statutory law. So I know we here at Post in the division and in the legal department are trying as much as we can to make sure that everything that can be made public is made public, and that anything that is for whatever reason not made public, that there's a very good reason for it. I don't know. Was there something else you wanted to say about that topic, Anne Marie? Or?
Well, I think just in the case at hand, we had a situation where it wasn't so much about identity or PII, but it was more about the sensitive material.
Right.
And if the commission, for whatever reason, felt that sensitive material, albeit difficult to watch and might be something that you would want to censor, needed to be made a matter of public record, could they make that decision?
Right. Absolutely. And I think in those circumstances where there isn't really a compelling reason why the information must remain confidential, if the commission wanted it to be made public, it could. And obviously that can be sensitive because sometimes there are victim privacy issues, right? And then the question is, well, perhaps if we're going to make it public, we're going to redact blur the faces of individuals who we don't want, that information to be made public. But those are the kinds of things we would be thinking about, I think. Okay. Yes, go ahead, Rick.
Not now, but before I forget, so when you're done with this, can we talk about, and probably after lunch, any point in the process where the officer approaches Post staff with a settlement offer,
Oh, sure.
and how those things are handled at different stages along the way? Because assuming there's a different different process depending on where it is in that stage and who has the authority, who doesn't.
Absolutely. Is there a logical point you want to talk about that after lunch, Anne Marie, or do you want to just talk about it now?
No, we can work it in after lunch and that way we kind of stay on task, but I think there's, we will make sure we work that in procedurally because at any point in time,
Yep.
the officer's representative can say, hey, I want to offer settlement terms. And it can be from the point that we've made a decision and filed a notice of intent all the way through where we filed an accusation. And oftentimes, in my experience, it was after the accusation was filed. It's already before the state of California, and we're moving forward with an evidentiary hearing. And then in fact, OAH, the Office of Administrative Hearings, in some situations will actually kind of enforce a settlement hearing to see if there's an appropriate resolution that you can reach outside of a hearing. And they typically do that if the hearing's going to last 4 or 5 days or longer. They will want you to do a settlement conference with the officer and the officer's counsel. So I'm quite certain we're going to encounter that as well, doing these proceedings, but I don't think there's a specific time where it's off the table, unless, as a division, there's no reasonable resolution outside of decertification.
And I think one thing that's important, and again, we can talk about it later, but just so you know, this is not going to be done out of your view. So in other words, a settlement agreement, let's say that the division enters into a settlement agreement with the officer, that's not final until the commission sees it and approves it. So just so you know, any agreement like that, the lawyers will put in a standard provision that says, well, this is the party's intent and this is what they're going to ask to be adopted, and the parties will comply with the terms until the commission gets a chance to thumbs up or thumbs down on it. So you will see them. Okay.
Where's the board at in that?
I'm sorry?
So the settlement agreement
Yes,
with the division and the officer
yes,
is done, and then you jump to the post.
yes.
But is the board in that process?
The board is not.
Okay.
So again, this could be something that again, Anne Marie was mentioning in terms of some discussion about other ways for the board to have additional involvement. But the legislation says the board's involvement is at that stage one, that first stage one hearing. And then the board is not involved in stage 3, which is what we're going to talk about now, or stage 2. The board is just not statutorily, there's no provision in the law for the board's involvement at that stage. Its involvement is earlier on, have that seat at the table, make sure the record is correct, and then to present that recommendation to the commission.
Maybe I wasn't clear. So the division does an investigation,
Yes,
concludes that the officer committed some egregious act, and his attorneys they negotiate with the division on some kind of settlement agreement. In that process, then it goes to post to agree or not with this settlement decision, but it still overjumps the board.
I see what you're saying. I misunderstood your question. Very good question, and I have to be honest with you, I'm not sure I had thought about that until now. So thank you for raising it. I think that the legal analysis would be, and Anne Marie, I'd love to hear with your licensing experience, to hear what your thoughts are there. But I think the analysis would be that at that stage, if a proposed settlement agreement was reached with opposing counsel, it would go to the commission. And the commission would determine whether or not to adopt it. Now, the commission could reject the settlement agreement and kick it back to the division, and the division would then start the process, which could bring the board right back into it again. But the settlement agreement is something that I think you're right. I think that would go directly to the commission just under normal law. But Anne Marie, I'd love your thoughts on that too.
So we didn't have the interim, in my experience, we didn't have the interim civilian oversight board. It was the board itself was making the decision, and there wasn't this intermediary board making a recommendation. But I think to Toby's point, because it's a final decision, it would go directly to the commission in terms of those negotiations. Again, depending on what stage of the process it happens. So what I could foresee happening was it goes before the board, because the officer at that point is this is their first attempt at being able to make a public comment and appealing to an oversight board to say, this isn't what you think it is. If the board were to then recommend some form of discipline, at that point, it would probably be the point where you would see an officer saying, or the council saying, we want to start negotiating settlement. Prior to that, they haven't really had their day in front of anyone, right? So it's really difficult to see what's going to happen in that forum, in that public forum. I think the more likely thing to happen is they want to surrender before ever having to do any or come before a public appearance. And that would not be a settlement, that's just a surrender. And I think we've already experienced that at this point.
And that's an important point that I'm glad you brought, Anne Marie, and that is that the commission is the body that state law gives the commission the authority to take the licensing action. So the determination to revoke or suspend is the commission's. The board's authority is recommendatory. I probably just made that word up, but the board evaluates and makes the recommendations, but the body that has the power to actually take away the individual's right to practice the profession is the commission. And so since that is ultimately what a settlement agreement does, it would go to the body that has that statutory right ability. So, okay, real quick, because I think I've eaten into our lunchtime. So, well, we'll give you more time, don't worry. But I'll do it quick. Stage 3. So now the proposed decision has come back to the commission. The proposed decision is presumably going to be pretty in-depth. The ALJ is going to talk about facts, talk about the evidence, make findings of fact, come to conclusions of law. There'll be attachments or exhibits with respect to it. And in that, the judge will also have a finding or recommendation with respect to the discipline that the ALJ believes that's appropriate. Now, those come back to the commission, and the commission will look at that, and the commission can decide what to do. So you might think, what? I don't get it. What's going on? Well, we've hired, under state law, we've hired the ALJ to do these hearings for us. But again, the commission is the body that has the legal right and ability to make the ultimate determination. And you can choose to accept or reject or modify the ALJ's decision. So I'll just go through real quick. We only have 100 days. Commission can just adopt it in full. And this happens all the time. I used to do these hearings before the State Personnel Board, and we just get a cover page saying the board has considered it and adopted it, and the proposed decision is now the order of the board. In this case, it would be the commission. So you can just adopt it in full. Commission could look at it and say, it's solid, we agree 100%, and we want to adopt it. It can reduce or mitigate the proposed penalty. So in other words, let's say that the ALJ says that it should be a revocation case and the commission thinks it should be a suspension. Well, it can change that proposed penalty. It can make technical changes or minor changes, and we don't have to talk about the details of that, but it can do that and then adopt the balance of the opinion. It can also reject it. It can reject it and can then refer the case back to the OAH, asking the OAH to take additional evidence and to then render a revised proposed decision. Or it can reject the proposed decision in its entirety and decide the case upon the record. One thing that's just important for you to know, you're probably not going to see in the normal course of these the full transcript of the hearing. The problem is it takes a long time and it's very expensive to get that proposed transcript. So how it works in administrative law land is that at the time the board or the commission in this case rejects the proposed decision, that triggers the preparation of the record before OAH, and then the long record is going to be typed out. And it would be possible, I suppose, for us to get it earlier, but generally that's what happens. So, but in that event, the proposed decision can be rejected, the record would be prepared, and then all that can come back to the commission, and the commission can then decide what it wants to do with it. Maybe at that point, after it gets the full record, it decides, you know what, never mind, we want to adopt it. Or it might decide, no, we're going to view this evidence in a different way, and we're going to come out a different way, and the commission can ultimately adopt that new decision. And then once the commission does have a final decision, that is filed It is a public record. Copy is served on the agency and the party's attorney if they have one. And then that's now subject to judicial review. So now after all of this, we have a final order. The attorney can then decide to challenge it and file an action in Superior Court to claim that the administrative proceeding was irregular or, whatever. Yes, go ahead.
So if the commission, let's say the ALJ recommends suspension and the commission feels strongly that it should be a termination,
Yes. Revocation.
or revocation, what would that process look like? Would we decide on the record and what would that look like?
Yes, so the commission could decide to, well, it says reject or mitigate the proposed penalty. But presumably, Anne Marie, I'd love to have your experience on this. Presumably, if the ALJ recommended suspension, the commission could change the penalty, but adopt the balance of the decision.
Absolutely, that's exactly what it is they're just adopting the balance of the decision that there was clear and convincing evidence to suggest the officer has been found to have committed one of the 9 acts of serious misconduct. However, the imposition of discipline is going to be modified accordingly, and that's the commission's discretion. Yeah.
Okay, I think that was it for me. We
Okay.
going to lunch?
It's lunchtime, so Chandler's going to give you instructions.
Okay.
Enjoyed lunch. It sounds like we're all having really good conversations, but so that I'm using a gavel now. I did.
Do you feel powerful?
That's what happens. It went to my head. It only took 4 hours. Okay. So thank you guys for reconvening. I know we left off right at kind of the final stages of the appeal process and what it looks like when we get something back from the administrative law judge. And there's other things that we know we still need to cover with you in that regard, because there's all the minutia in between the layers that are questions that you guys brought up today that we really want to make sure we answer. So if there is something that remains unclear about the process, make sure you bring it up, even if we're beyond that phase of the training, because that's the most important aspect of what you do, is understanding procedurally the guardrails that we operate within. So thank you, Dr. Glazier, for bringing up the, kind of board situation and the governance of the board. And then the same is true for questions about what the commission can and can't do even after an ALJ decision. So the very last thing I want to touch on, why Michelle's choking, I'm going to give her time, is we have a cough drops over here, is that when you have a situation, and board member Pena asked me this offline, but I think it's important to share with the rest of you, is it common for boards to be able to non-adopt or reject an ALJ's decision? It is. In fact, that is the crux of the APA. So this is not unique to peace officer decertification. It's not unique to the process that was set before you in SB2. This is what the APA's, the Administrative Procedures Act, gives the governing body of whatever profession they're regulating the final decision. So this was set up for the commission, just like every other licensing and enforcement APA provision that's out there. What happens though if you non-adopt an ALJ's decision, you reject it, you write your own, and the officer believes it's completely unfair? Toby touched on they can file an objection. Is it a writ at that point, Toby, with the Superior Court? It is a writ. Okay, so it's a writ of mandate with the Superior Court. Now, if they don't like the Superior Court's decision, can they take it to a higher court? Okay.
Yes, absolutely. So the writ of mandate is a trial court decision like any.
Okay.
And if they don't like the trial court's decision, it can go to the Court of Appeal, and then that can ultimately go to the Supreme Court.
Okay, so Margaret. Yeah, it goes to Superior Court, Court of Appeals, and then it can go to the Supreme Court. California, sorry. Yeah, yeah. Okay. To appeals, yeah, to Supreme. Okay. All right, so on that note, I'm going to turn it over to Michelle Weiler. Michelle's another bureau chief within Peace Officer Standards and Accountability Division that oversees the licensing side, so the certification side of what we do here at Post. She's going to talk to you about some of these final decisions and the responsibilities. We touched on them earlier. Michelle's going to show you what it actually looks like once those decisions are actually implemented. Thank you.
Good afternoon. I'm going to apologize in advance. In case I start hacking up a lung, this weather is killing me and I have a cough drop. So if it sounds a little muffled, that's why. Yes, so this side knows me very, very well. This side probably not so much. So my name is Michelle Weiler. I am the bureau chief of our certification bureau. Some of you may have heard me use the analogy of we're the bread in the officer's career sandwich. I've now expanded that analogy to being the bread in a club sandwich because we are throughout the officer's career. And now I'm going to adjust that top layer of bread. Trying to make it a little funny after lunch. Wah, wah. I'm a white bread person or focaccia, but those don't make very good club sandwiches. Okay, so after the commission renders its final decision, Post as an agency, we have some responsibilities to the public, right? And as well to the law enforcement community. So some of the things that my bureau is going to be responsible for at this point is anytime there is some sort of action taken against a peace officer certification, we will update what is called their EDI profile. EDI stands for Electronic Data Interchange, for those of you not familiar with our internal database. So I've got a few screenshots to show you what that would look like on an officer's profile. So if that peace officer were to request their own profile, a potential employing agency were to request a profile, even a member of the public can request that. You would get a redacted version so that the officer's personal information is not released to you. And what the Post profile is it's our record of everything related to that officer, their name, their birth date, their Post ID number, which is individual or specific to each individual peace officer. Kind of like your driver's license number is individual to you. It also is a record of any certificates they've been issued, any peace officer employment that they've had with a Post participating agency. We are just now starting to track agencies that don't participate in our program. And any training that they've attended that is Post certified. That's not part of this screenshot, but you'll see this top screenshot shows ineligible for those that we'd mentioned earlier were deemed ineligible due to a felony conviction. As listed in Government Code 1029, there's a little footnote and a banner that go with that. Poor Sarah Connor, she's been through a lot. She's now been temporarily suspended. I think the terminator took, a toll on her. And our executive director has now deemed it necessary in the interest of the public health and safety to issue an immediate temporary suspension. So that will show on her record. When Andy Sipowicz, he's been through a lot too. He's done with his career. He's turning in his certification. He said, I'm done. So he's surrendering his certification. That also goes up here. And you'll see on all of these, it'll show invalid. Under their certification, the comments shows invalid when they have been, their certification is no longer active and in good standing. And then Jason, sorry? Yes. That's a good question. It will show surrendered on here if the other state does their due diligence and completes a background inquiry with us. We would give them this information and advise them it's been surrendered. These are also reported to the National Decertification Index. So again, if they're doing their due diligence and checking the NDI, they will also see that it has been surrendered. Now, we don't regulate each state, so each state may look at that differently. They may contact the prior employing agency. They may contact us for further information on what that surrender means or why they surrendered. In some circumstances, we might be limited in what information we can release to them because an officer can surrender their certification at any time for any reason. It doesn't have to be related to serious misconduct. It could be at any point during an investigation as well. And if it's in the early infancy stages, I think Anne Marie mentioned earlier, a letter of investigation, they receive this letter and say, we've received this allegation of serious misconduct. We are going to be investigating this case, and maybe they know, right, that it's not going to go well for them. They may choose at that point to surrender their certification. We may not have all of those reasons available for an out-of-state agency, but we would advise them of what we can.
Tell me this all the time, I'm sorry. So they could they could reapply for certification, let's say in another state, Oklahoma or New York.
In theory, I suppose they could. I can't speak for the other 49 states. I can tell you in California, it is equivalent to a revocation when you surrender. So you cannot be reinstated unless I guess you took it to court and the court says so. But at this point, they cannot be reinstated in California.
Okay, thank you.
So revocation and would follow the commission's final decision. That second go around with the commission, if they decide revocation is the way to go. Same thing if surrendered was determined to be the way to go, then you would see revoked or surrendered. The only difference, and I don't have a screenshot for it, is with surrendered, you would see where it says invalid, you would see a comment there with the time period for that surrender. So if the commission decided it's a 2-year suspension, you would see the start and end date for that suspension period there. That would be reportable to the National Decertification Index as well.
I'm curious to know. So,
You pushed it.
yes, I'm an officer in New York and I surrender my certification. I go into the National Decertification Index as a surrender. I'm now applying for a position here as a police officer in Sacramento State. Is post then looking at the national index to identify myself as one that has surrendered and then make a determination of whether I can be licensed here?
So I can't speak for New York's processes if they put them in the National Decertification Index, if they
But
surrender or
I'm just
not.
saying, we
But
know it's not federal regulation that they have to, but we just say that I was put in it.
yeah, so agencies in California are obligated to check the National Decertification Index for any of that information. Yes. I just wanted to clarify that I don't know what New York does. And then the next step, once the EDI profile is updated, we would then publish information to our Peace Officer Certification Actions page. That is on our post website, which has been redesigned recently. So you may have to make a few extra clicks to find it. Just for your information, if you go to the top of the page under certifications, there is on the left side, you'll see some options, and there is one for Peace Officer Certification Actions. This list will then pop up. I actually just updated it during lunch. And it will populate with every peace officer we've taken any sort of action or determination on. Those that are deemed ineligible due to felony conviction, temporary suspensions, those who've surrendered their certifications, and ultimately those who may be subject to suspension or revocation. As Anne Marie mentioned this morning, there have been some revocations already. Those are currently on this website. And it is currently listed here alphabetically. You can sort any of those upper tabs or heading columns. You can sort by that. If you want to look by agency, if you want to look by last name, you can click any of those and it'll sort by that alphabetically or by date.
One more, I have another question
Mhm.
concerning the national database. Biden and of course Kamala created an executive order to create this national database. I forget if it includes officers from the state as well as the agencies within the state of California, well, in the nation. But there's a database that collects bad acting officers that they had just passed an executive order. Now, do we report to that database also?
My understanding is that database is not fully functional for peace officers. Right now, it's for federal agents, that they have to report federal agents to a national index through, I believe, the US Department of Justice. But I don't think the regular law enforcement national database is something that has been completely fleshed out and rolled out. Our executive director might know a little bit more about that, but that's my understanding, and I can get clarification for you. Thanks.
But we do report to the National Decertification Index, and not every state reports to that. It is voluntary right now. We've just joined that process a year ago. We've been reporting to that. So that is something that is out there. I do not have a screenshot for that. I think that's actually, oh yeah, there's a bullet right there. I don't have a screenshot for that because that is a law enforcement access only site at the moment. So I didn't want to put something up that I'm not allowed to share. But just trust in that we are reporting to that. I'm actually the one doing it. So that information is out there for anybody going to other states. They can search that as well as contact us directly. Oh, I actually did also want to share, immediate temporary suspensions do not go in the National Decertification Index because that's not a permanent action or an action rendered by the commission. That is the executive director's discretionary issuance. And at any time that can be withdrawn if there are appropriate reasons for us to withdraw that. So that is not reported to the NDI. Everything else is.
Question for you.
Mhm.
If someone is on immediate temporary suspension, that administrative revocation that's not permanent,
I can't hear you.
Oh,
could an officer who's had, or a deputy who's had that temporary revocation done, could they then go to another state during the pendency of that and apply to another organization and not have that a reportable item in the record?
in theory, they could. I don't know how successful they would be. I would say, as the Bureau responsible for responding to outside agencies' requests for background inquiries, we do get them from most other states, and we do provide this information to them because it is a current part of their record that they are under a temporary suspension. So we do report that to them. But it looks like Manny wants to add something.
So Anne Marie just asked me to come up to clarify some of the information to NDI. So in answer to the first question that you posed about the federal database is for federal agents. It was just rolled out recently. It is for misconduct of federal law enforcement folks, and it really has nothing to do with us, at least at this point. And it doesn't look like there's going to be any changes in that regard. The National Decertification Index is undergoing some changes. The federal government is putting some money behind it and also trying to create some standards for what goes into that database, because right now it's voluntary and each state can decide what they want to send in there, send to the database. So for instance, in California, one of the requirements, as Michelle put out earlier, is every new hire, the department is required to check NDI. And we audit them to make sure that they did check NDI. But just because somebody is listed in NDI does not disqualify them from being a peace officer in California, because some agencies or some states put stuff into NDI that would not be a disqualifier in California. So the agencies have a responsibility to check the database and see if they are in the database for something that would be disqualifiable in California. So they have to do their due diligence. And then I'm sorry, what was the second one, Anne Marie?
I think you answered it.
Okay.
Yeah, it's just the peace officer government owned and operated decertification index is not something that's unfolding. It's for federal agents. But
I think I know what the second one was
Yeah.
now. The second was if there is an ITS,
oh,
if somebody has an immediate temporary suspension in California, can they go to another state? And if that other state allows them to, yes, they could. It only obligates law enforcement agencies in California not to be able to hire the person or for the person to serve as a peace officer. So we could, in theory, decertify somebody in California, and some other state may say, hey, we don't care, and we're going to let this person be a peace officer. So yes, it only applies to stuff here.
Manny, first of all, I think I remember telling you that I saw that Texas was in fact saying, even if you're decertified in California, apply for jobs here. So, you know, they can be as blatant as that. But one thing you said, I'm not sure about. So in California, any post-certified agency cannot hire somebody who's on the decertification list. Is that correct?
They are not allowed to hire somebody who's in NDI or on the NDI list for something that would be disqualifiable in California. So I mentioned at a commission meeting a couple of
What's the
years
difference
ago.
between that, Manny, and after the end of this process, if it's determined that someone either by default or by action has been decertified?
Mhm.
Did you say something else other than they necessarily then can't work as a police officer in the state of California?
No, in theory, they can. The department just has to do their due diligence. And I'll give you an example. Some states will suspend or revoke an individual for not passing their annual firearms qualification test.
Right.
And they are in NDI. I presume that those individuals can be hired in California because they're not in NDI for something that is a disqualifying event in California. It's not one of the 9.
Right.
So they have to do their due diligence in that.
But if someone is, for lack of a better term, guilty for one of the disqualifying serious conduct, then they cannot be hired by a law enforcement agency in California?
Correct. And we have had one of those already in California. If I may give the example of it, Anne Marie, and correct me if I'm wrong, there was an individual who's a peace officer in California, and prior to SB2,
Right.
he was serving as a peace officer for a number of years.
Mhm.
SB2 then kicks into gear, and he had separated. He then went to go get a new job as a California peace officer,
Right.
as he had separated. They checked NDI,
Right.
and he was listed in NDI for something that was a disqualifying event.
Okay.
And we ultimately sent him a letter saying, you are ineligible to be a peace officer in California from here forward. And he had already served as a peace officer. So they are checking. We audit them to make sure they check, but they still have to do some due diligence on their end at the department.
What if it were not, what if it were one of those agencies that was not post-certified?
You mean in another state?
Here. So there are some agencies
Mhm.
that are not post-certified, not a lot, but some.
Sure.
I can't think of an example of one. Maybe one of you can.
So there are, as was mentioned, 614 agencies. We audit them to make sure that they check NDI.
Right.
There are 20 other agencies that are not part of post,
Right.
fall under SB2. We audit them
Okay.
as well. Now we've started to review their personnel hiring files,
Uh-huh.
but there are other departments, a few of them out there that do not fall under Senate Bill 2, that are not post participating, that we don't go and check. And I don't believe that they're required to check NDI. But that's up to them if they do or want to.
So there's no repercussions, like, for lack of a better term, a crime isn't being committed by a law enforcement agency if a local law enforcement agency hires someone who's been deemed decertified.
Correct.
penalty
So
for
you're
that?
saying can a non-post participating agency could, in theory, they hire somebody who's listed in NDI and that person work as a peace officer? And I presume, yes, well, let me take that back. It's in 1029 that they can't be in NDI now. So I believe, and I strike all of that from the record, if
okay.
I may, Madam.
And I certainly
Chair
don't
from
put
the
you on the
board.
spot. I'm just
It's
lost.
actually now, it's not just for post-participating agencies. It's
Okay.
in the government code, in Government Code Section 1029, for all peace officers, I believe all peace officers, they cannot be listed in NDI for something that's disqualifiable. Is that correct, Anne Marie or Michelle?
I think Anne Marie's looking it up.
Yeah, I'm getting help from the audience. They're sending me messages. So yeah,
Anyone
it
who wants
is.
to answer this, just step up.
It is 10:20. Yeah, who's ever sending the messages? It's great to have people. So it does say any person previously employed in law enforcement in any state or United States territory or by the federal government whose name is listed in the NDI of IATLS or any other database designated by the federal government whose certification as a law enforcement officer in that jurisdiction was revoked for misconduct, or who, while engaged as a law enforcement officer, engaged in serious misconduct that would have resulted in their certification being revoked by the commission if employed as a peace officer in the state. And so that's anyone, not just post-participating agencies.
And certainly an example of that might be a felony. You know, someone's been convicted of a felony, you know. Anyway, I think we got, the lawyer in me is done. Anybody else?
And current
Leave
invalid
it.
then goes up here.
Add
Yeah.
just one more, nuance to it. We know an officer who had basically not so much been decertified, but got a felony for murder. And of course, upon serving his time and coming home, he changed his name. It's not clear to us yet whether he's been reemployed as a police officer, but it's rumored that he has been. So do we, is there a way to track whether an officer has changed his name to be purposely reemployed as an agent, a police officer in the state?
I don't know.
So we track individuals by their name. What you don't see up there is their date of birth sits in a separate database as well as their social security number.
Okay.
So that's how we would match them up, that it's one and the same. And there's an AKA on those EDI profiles. So we do every now and then, have conflicting records or somebody who has two profiles, but that's how we marry them up. Okay. Their social and their date of birth. You just don't see that up there, nor do we have access to it. It's kept separate by our computer folks.
Okay.
Yep.
And if I can, one point, just point of clarification, Joyce, for your question. So Senate Bill 2 does provide that the certification program established by Senate Bill 2 applies to two discrete groups of peace officers. One, peace officers employed by agencies that are post-participating. Two, any peace officer in the state, regardless of whether they are employed by a post-participating agency, that is appointed under certain defined penal code provisions. So it's 830.1, point 2, with the exception of D, point 3, point 32, point 33. So if you're a peace officer in one of those categories, even if you are not employed by a post-participating agency, Senate Bill 2 applies to you. For those peace officers, the ones I just described, the post-participating agency and those, whether or not they are post-participating, that are hired in that, within those penal code sections, there is a requirement in Senate Bill 2 that any agency that employs those peace officers may only employ a peace officer that has a current valid certification in California. So in that circumstance, Senate Bill 2 would permit the agency and would require the agency and would permit post to say that those individuals cannot be employed as peace officers in California unless they have current valid certification.
Excellent. And again, no overflow to any other state. This is state law in California,
is state
so
law, correct.
any other state can see the person's decertified and still hire them.
Correct. Each state makes its own decisions on who it is or isn't going to hire.
Okay, thank you. That did it. Any other questions about that? I know I ran with that one, but I want to make sure everybody understands that too.
Yeah, and real quick, the name change would come up when the agency runs their prints. Because you can send some fingerprinting, so it's going to come up based on that database, similar to what Manny said. So it would pop up as a name change, and then the decertification would naturally follow from the investigation on that name.
You're also required within the hiring process, you have to have an original birth certificate. So even with the name change, that is another stopgap that you have to have within your post background packet. That is another thing that post audits. So every single background that as an agency we complete, whether it's hire or no hire, post actually audits all of those every 2 years. So you literally hand a stack, very large stack, to your post consultant during the audit. But that is one of the major checks, is that they have to have a birth certificate. So there are multiple ways that should actually be caught.
I'm gonna add one more thing, because I don't know if we thought about covering this, Michelle, but this kind of lends itself to post can deny issuing the certification as well. We've had occasion where we've had to cancel certificates by way of coming across fraud, misrepresentation of a peace officer's minimum qualifications, that there was something through the process where they misrepresented facts. And we have had to go back and cancel that certification because they did not earn a valid, clear certificate through post. So that's something that we don't focus on a lot on the licensing actions as a result of SB2, but these are licensing actions as a result of SB2 that don't follow the traditional serious misconduct pattern, but are in fact something that we can do now that the provisions have included things like holding a valid certificate, what it means to have a valid certificate, what you have to do to obtain a valid certificate. So if any of those provisions are violated and we learn about that, there's also a licensing action or reaction, if you will, that we can take now.
And to add to that, as well as what Commissioner Gordon and Commissioner Brazil mentioned, we are also now able to cancel appointments and certificates for individuals who do not meet those minimum requirements to be a peace officer. So as Commissioner Gordon mentioned, we do conduct audits of these background packages. When the agencies hire somebody, we audit those on a regular basis. And if our consultants find a deficiency in that package, so say a medical evaluation wasn't completed, it's missing a valid birth certificate, we give the agency an opportunity to remedy that situation. Maybe they just forgot to put it in the file when the consultant came out to view it. Maybe it is actually missing. At a certain point, if they haven't remedied that deficiency, we can then move forward and take action and say this person is, in our eyes, not eligible to be a peace officer in the state of California because they don't meet these minimum requirements. Therefore, we are canceling their certificate and their appointment. So that SB2 has given us a lot of ability to do things outside of the serious misconduct, as Anne Marie mentioned. That is also one of the things that my bureau is doing. You know, we are trying to close some of these loopholes, some of these gaps. So, Anne Marie alluded to earlier that we are going to have start to have some live data available in terms of agency reporting. You know, how many officers work for an agency? How many allegations of misconduct have they been reporting to us? This is a screenshot of what it, I think, is tentatively going to look like. Have we made changes? I put this up a week ago, so you know, with technology, things change all the time. So this was live data a week ago, but you can see it's how many full-time peace officers, how many basic certificates. It says 0, but that's based on this calendar year so far. You know, how many terminations, et cetera, all the way across. So this will be available for the public to see as well. And that's just another piece of transparency, right? And also kind of keeping some agents may not even be aware, right? We had an incident last week where an agency forgot to apply for a basic certificate for that officer, and they weren't aware of that until another agency out of state tried to hire that officer. So this is also kind of an awareness for the agencies as well, right? And this will be sorted alphabetically. And then here, I know this has changed, but this was also a snapshot of what some of the data that we'll be including in our annual report to the legislature, as well as making it available for the public to view. So you can see how many cases we have open, how many cases are actually still pending agency investigation, and how many are currently with post. You can also kind of see, you know, a bar graph of how many misconduct allegations have been received for each category.
Michelle, can I add one thing here? Couple things. In terms of the agency reporting data that we showed you, the commission had asked staff to send notices to what we would consider 0 reporting agencies. I think I might have mentioned it to the board when we met. We sent approximately 270 letters to agencies that had not reported any serious misconduct according to our records. Really, the goal there was, one, to let them know that we're going to be doing this, you know, public notice that this will be an ongoing reporting dashboard on the Post website, but also to make sure our records were accurate, that we weren't missing something from an agency. And so we did get a couple of responses back. I think there were maybe only 2 agencies where there was something reported, but it came through a public complaint. So somehow it didn't get tagged to that agency, and we were able to rectify those records. So just so you know, the agencies have all been aware that if they haven't reported anything, one, they have an obligation to do so. That was part of the letter. And that we are making this information available, we are making this information public. And then it will be an ongoing reporting tool. There were not responses from the agencies that they were unaware. So most of the agencies that had 0 reports were agencies that were very small and only had a handful of peace officers and did not have anything to report. So there were no serious misconduct reports. That's not to say that we don't have very large agencies that are still underreporting. So there's a difference between no reports and then is this a representative number of reports that we should see from an agency that has 2,000 peace officers? So there may still be some underreporting, but at least we've captured those agencies that we did not have any reports from. The other thing I wanted to mention is on the certification action page that Michelle went over earlier, that includes the ITSs and the 1029s, the immediate temporary suspensions, and the revocations for felony convictions and ineligibilities. There's 150 actions currently taken by Post. So just as, piece of information for you, to your question earlier, Mr. Johnson, how many actions have we taken? There's a total of 150.
I just want to comment on that. I'm not surprised, but I do appreciate how Post, and in this case, you and the agency, go beyond what's expected of you to ensure professionalism. So thank you.
Thank you.
And Anne Marie just reminded me, you'll see an empty column for accusation. So if at any point one of our cases reaches the ALJ, you will see there a hyperlink to those documents. So any member of the public can then access those documents because it will be on our public facing page. We don't have any cases at that point yet, so there's nothing there. And then you'll see Mr. Aguilera, originally we issued a temporary suspension. And then because we sent him a notice of intent to revoke and he failed to respond, he is an example of that automatic or that default revocation because he failed to respond to that. So you now see that there's a revocation for him. So anytime you see a red strikeout, there's been a change in their status.
Mr. Aguilar's case, that would be a case where he was given 30 days to respond and he did not?
Correct.
Okay.
Here's just another another page of what will go in our annual report. This data is slightly old. We currently have 12 voluntary surrenders. They are a combination of a response to these letters of investigations, just voluntary surrenders, as well as the district attorneys are now using the voluntary surrender as a tool. And so we do have some surrenders as a result of a plea deal. And some of those are active cases that we had, and some of them were cases we were not aware of because they weren't one of the 9 categories of misconduct or a felony conviction.
As Michelle mentioned, this is an example. When the annual report is published, it'll look a little different because the numbers have been updated. Something I want to call out here, if you look at the lower right-hand corner, it says compliance audits or reviews. So this kind of goes back to what Dr. Glazer talked about before, which is at what point are we going to audit the cases that were closed or even cases that move forward? So the legislature has an expectation that there is some audit conducted of the work that Post is doing along the lines of officer decertification. So these headings are all tied to the legislation in 13.512. And that's why we're reporting out on them. So there is this expectation that an audit will be conducted at some point to kind of verify that we understand the intent of the legislation, we're carrying out the intent of the legislation, and there's some accurate record of that.
And I believe that brings me to the conclusion of my presentation, if there are no other questions.
Thank you, Michelle.
Yes, Mr. Brazil.
Michelle, I just have one suggestion is that we put somewhere on the list, decertification list, or the status, employee, their status, some kind of definition so people know what temporary suspension, revoked, and eligible, what those mean?
So those actually lie at the bottom of the page. But I
All the way
did
down after
include it in a
150?
screenshot.
All
When
the
I
way
first
down.
put them on there, they weren't that far down.
Oh, it's way down. I've rearranged the list multiple ways. Kind of cool. I like it. Okay.
But we are,
Hey.
we are open to suggestions, any addition, any way that we can improve on this information for public consumption. I'm open to that.
I think Rick wants it at the top of the page.
I think that's what I
That's
got.
I heard.
yeah. As the list got longer, I think it's probably a good idea to put it at the top of the page.
I didn't say that.
We're picking up what you're putting down.
He's given me a lot of those subtle hints over the years.
Thank you. Thanks, Michelle. I appreciate all your work. This all looks really seamless, I think, at least from Michelle saying, hey, you enter a code here, it does this, and then it notifies the officer. It's actually a lot of back end work with EDI to make all of this happen. So Michelle and her team, in addition to taking in one thing I don't know that Michelle covered, but this is an important aspect of all the discussion we had about backgrounds, right? And investigations when we're going to issue a certification. Michelle's staff also takes in requests from officers that want to know what records Post has in its possession about them. So they actually have to go review our serious misconduct database, and we provide records to the individual peace officer, the peace officer that's requesting their own records. We have to notify them what records we possess. Obviously, we don't disclose investigation matters, but we will disclose if we have a case of serious misconduct that's moving through the process and what the allegations were, because they are entitled to know that through Senate Bill 2. So that's another important aspect of the work that the Certification Bureau does. And sometimes that gets tricky because we may have an ongoing investigation, or the agency may have an ongoing investigation that the officer is unaware of. And then it gets filed with Post. So we have to be really careful that we don't disclose something that could otherwise jeopardize an investigation that's being conducted at the agency level. So it requires a very delicate balance. Michelle's team is in communication constantly with our Professional Conduct Bureau when we get those requests, and those requests come in all the time. This is kind of a normal thing that happens here at Post, but just thought I'd mention because there's a lot going on there.
Yeah, I think it speaks to one of the earlier questions. Agencies within California, if they are bringing in a lateral peace officer, so someone leaving one California agency to another, they are obligated to contact Post to determine whether we have any allegations of serious misconduct. Actually, they're required to contact us for reasons for separation from their prior agency, and then they may ask us about allegations of serious misconduct, and we're obligated to provide what information we can. That is handled by my team. Usually when an officer is asking for that information for themselves, it's because they tried to transfer somewhere and they were told that they couldn't be hired because of the information in the background letter that we sent them, or they received that letter of investigation and they want to know what we have received. And just to reassure our law enforcement personnel in the room, we do have checks and balances in place. All these letters go through a second level of review by a supervisor prior to being released to a background investigator or the subject officer.
I have a question.
Sure if I, oh, go ahead.
So is this information being provided to all the agencies and Post quarterly or yearly, or
Which information?
the information you just talked about?
So funny you should ask. We are in the process of putting out, when we first started, we had some newsletters that went out. We are in the process of revamping those quarterly newsletters to provide any updates to legislation, updates to our regulations. We are providing them a statistical snapshot for that, whatever that period is that we're reporting to them in the newsletter. So that, I think the first one's going out next month or the end of this month. So we are doing that, but as far as a regular blast to each agency, I don't know that we're actually doing that, if that's your question.
We're
That was-
sending the agencies an email to let them know that this information is available on the website so that they know they can at any time go in. They'll be able to filter. We don't have a screenshot of what they'll be able to filter, but they'll be able to filter what we consider kind of a roll-up report of all the agencies reporting. And they can filter that by year, they can do an annual snapshot. They can do a from the beginning till current kind of thing. And this is something that this will live on the website. So it's going to always be up there and it will update overnight, every night that there's input, right? So we are sending kind of an email blast out. So the agencies know that it's up there before their constituency might know and calling them and asking them about this data that they may not be aware of. We're making sure that we send an email blast out.
Is the information being provided to, when you say, the agency, is only the chief or the sheriff getting this information, or high level? I'm trying to figure out what level, is it a high level type of report being sent? Or,
So I believe our mailing list, if you will, is just any interested party that's requested information. But yeah, it goes to agency heads, and it can also go to people that have signed up to get notifications from Post. That's how we would kind of blast this, if you will, to the field.
okay,
Yeah.
thank you.
Mr. Jones, you had a question as well?
Actually, let's see if I can figure it out. I heard you use the word required, and I thought it was connected to an agency that was, went to the national index of decertification, discovered that this officer is from the state of California, and there's some stipulations that they're required to contact Post to make a determination of what that decertification was about or something. I heard the word required. I'm trying to figure out what that was related to.
Yes, so not all peace officers that are applying for the peace officer position have previously been employed in law enforcement, and not all of them are from within California, so they're maybe from out of state. So that's where the agencies are obligated to check the National Decertification Index for any of that information. All California agencies are also required, and that's where I'm using the required, to contact Post with regard to reasons for a peace officer separation from a prior employment. Officers are obligated to disclose that information when they apply for employment with another agency, to say, say I'm going to apply to Sacramento PD and I had previously worked at Vallejo PD. And so then Sac PD will know that I'd worked at Vallejo. They're going to contact Post and say, hey, I want to, I'm following up on a lateral candidate. That's what we call them, lateral candidates. A lateral candidate from Vallejo PD, I'd like to request reasons for separation. Additionally, they can request any potential allegations of serious misconduct, and then we would release that information. What information we would release to them. If it's a pending investigation, obviously we don't release a whole lot of information there, other than to say that there is an allegation. Yes, ma'am.
Can you hear me? I'm sorry.
I can. I don't know if they can
Oh,
online.
so me, Regina, community person, as we know, this information, the purpose of it was supposed to be transparency. And this information is going to anybody who applies on that list. I would say one of the things that usually comes up when there's a police officer involved shooting, is this type of information being captured at Post as well?
My answer is going to be, it depends. Because it depends on the circumstances of that case. The agency is obligated to report certain uses of force to us. We may find something in the news and then reach out to the agency for an update. There may be things we don't hear about and we don't know about, but anything we do know about is captured in our statistical data. I hope I'm answering your question.
Yeah, so I would, okay. So the reason why I asked that question is because, as we know that, like I said, part of the SB2, and probably a component of it was left out as they dwindle it down, was the community was calling for transparency. And in that, a lot of times, I am not the person who does it all the time, but the other people in LA and San Diego are great for you know, it's almost like you have those little individual groups that know how many times an officer has been involved in police shooting. And yeah, he may have been cleared, but statistically in the public's mind is if I had Officer Sarah Connor and she was involved in 6 shootings within a time period of 6, 7 years, maybe she was cleared for these shooting, they found that it was a justifiable shooting. At some point, I'm speaking, you know, as community, the probability of her being a good officer may not show that she's a good officer. So is that type of data, would it be captured by post? Is what I meant by that.
Not
Not
necessarily.
necessarily.
Most agencies, I believe, keep that data. I don't know that that's made public, but most agencies do keep that data. What data we would have that's not necessarily going to be made public is that historical data, right? As we mentioned, anything that was reported between the 20 and 21 time period, anything that's been reported to us, but maybe we don't take action on because it's not actionable. We do have that historical data for our own purposes, right? If we continually see allegations of misconduct for somebody, we do see that. But again, as far as very specifics, if it's within policy and it doesn't rise to that level of serious misconduct as defined, the agency doesn't have to report that to us, and we won't have that data. So I guess our transparency only goes so far. That sounds bad, but it only goes so far.
There was actually a case in LA where it was an officer involved shooting, and it wasn't us, by the way, who brought up that information, and the community jumped on it, so that's why I asked that question.
I think Toby had
Sure,
an ad.
if I may. So the legislature has shown an increasing interest in ensuring transparency of these law enforcement records. And it did it in a series of laws, including Senate Bill 1421 and Senate Bill 16, which make these records now available to the public. And so that's how the legislature saw that these records should become transparent and available for public review. In Senate Bill 2, it did something a little bit differently. And it did mandate that agencies report this information, the complaints, charges, and so forth to post. And that information is available to the officer, to the employing agency, or to any agency that's doing a background. So if I'm going to hire an officer, and I know that, as Michelle said, and I know that officer's been employed by another agency in California, I'm required to call Post, and Post will say, yes, that person was separated from this other agency for that reason. So that's how within the confines of Senate Bill 2, that material is brought in. But in Senate Bill 2 itself, the legislature said the material becomes public at the time we bring it to the board. So that's when that transparency component becomes effectuated in Senate Bill 2. When we take it to the board, it becomes public. But I think you're transparent. If I'm understanding your question, I think the transparency was addressed in separate litigation. Separate legislation, Senate Bill 1421 and 16 and those bills.
Onset of SB2, that was probably one of the components that was removed, was when they were calling for transparency. This is what they expected and thought transparency looked like. But as we're moving forward, the report is wonderful. I love the report. That transparency probably is not there as far as post, is what I'm hearing.
Well, it is once what the legislature specified is once the matter is moved to the board, then that becomes public, all those materials become public, and any hearing becomes public. So that was, however, whatever the balancing happened in that legislative process, that was what ultimately came out of Senate Bill 2.
Just to reiterate, what's going to be posted on the website, ongoing website, public facing, is the data. So I just want to be clear, the emails just to let the agencies know the data is up there, but the data is available to everybody anytime on the website. And we're hoping to have that data available within the next few weeks. Thank you, Michelle. Bryant Henley from our Legal Affairs Bureau is going to talk to you about clear and convincing evidence. And And then Chris Becker is going to talk about the Open Meetings Act. So we're running a little bit behind. So Brian's going to do speed dating right now, and Brian's going to take you through this as quickly and effectively as possible.
That's right.
Sorry,
Not
Brent.
speed talking, hopefully, but we will try to move through this fairly quickly. And fortunately, because of Board Member Glazer's question, some of this we've touched upon a little earlier this morning, but we'll get back to it again. And as Anne Marie said, I'm Brian Henley. I'll be tag teaming with my boss, Chris Becker, I'll cover the clear and convincing evidence piece, and he'll dive in on the Open Meetings Act question. So speaking of questions, dive in anytime if a question comes up. We are going to try to move this along, but I want to make sure we've addressed your questions. That's the most important thing we're doing here today. So I'm not going to cover this slide for long. It's been covered many times, but I did want to highlight for the board members and the commission members, your lens is going to be slightly different, right? And I don't want to belabor this point because we've all talked about it. You're both looking at it from the standard of proof of clear and convincing evidence, but the board members are looking at the division's findings, right? Are the division's findings, are they sufficient to make a factual basis for revocation by clear and convincing evidence? So that's the board's lens. Do those findings, if the division's findings, taking them as true, do they, by clear and convincing evidence, show a factual basis for revocation or some action? The commission, on the other hand, also looking through the lens of clear and convincing evidence, the commission's going to be looking at the entire record before the board, and then the board's recommendation and saying, does that record in its entirety, does it support that by clear and convincing evidence that serious misconduct's been established? So same standard of proof, but a little different lens. The board looking at it through the division's findings, and the commission looking at the board's findings, the board's recommendation, and the full record. So I think I'm going to, as much as I love videos, we're going to skip the video just for the interest of time. But this is just an illustration of the concept of working through a clear and convincing evidence standard, but I think it really would belabor the point. Similarly, for this slide, it's a lot like the next one. So let's just go ahead and hop over to this slide. So really, I think in order to get a sense of what is clear and convincing evidence, one thing that would be helpful is to sort of take it in the grand scheme of other standards of proof and other burdens of proof that we have in our state and in the United States, because it gives you a little more context. And so really what we have here and in the prior slide is sort of a pyramid showing at the top, sort of the highest standard of proof we have in the United States, the proof beyond a reasonable doubt standard. And as we go down, we get into the lower standards, all the way down to standards that are used in investigatory tactics, such as when you have a traffic stop, or maybe a law enforcement officer has to make a pat-down search. That's a kind of an exigent circumstance. It's a heightened circumstance where you're not going to wait to see, do you have proof beyond a reasonable doubt that there's a person that has a firearm in their pocket? In the heat of the moment, like there's a bank robbery that's just been reported, an officer might need to pat down a person with much less proof, right? So you have a reasonable suspicion. Is there, more? It has to be more than just a mere hunch, but is there specific facts and objective reasonable inferences that lead an officer to say, that's enough for me to say I need to pat down this individual? A lower standard, right? But it's based upon the circumstances. As we go up, we get to the probable cause standard. That's for making arrests by law enforcement. It's also in a preliminary hearing where you've got criminal charges. A judge will look at whether there's probable cause to hold the person over for the charge. And as we go up, now we're into what are really the evidentiary standards. So the first two we talked about are more in the context of law enforcement investigative standards of proof. But really, from an evidence perspective, it's really when we get up here to this portion and up that we're really talking now about a courtroom or a board or commission hearing room where these kinds of fact-finding standards come about. Most civil cases have this standard that's known as the preponderance of the evidence standard. So for those of you who have actually ever served on a jury, it's more likely than not it was a civil case, could have been a criminal case. But if you've stood on a jury, sat on a jury, you were asked and you were given jury instructions that told you as jury members to look at, if it was the preponderance of the evidence standard, is it more likely than not true that those facts occurred? So when you're looking at the standard, the preponderance of the evidence standard, it's probably the lowest standard in terms of evidentiary standards used in California and elsewhere. But it really is, in a sense, 51% to 49%, if you wanted to put sort of some numbers around it. Is it more likely true than not true? If it's more likely true than not true, you've met that preponderance of the evidence standard. The next highest standard, also called the intermediate standard, that's the standard that applies to all of you. That's the standard you're going to be looking at. That's the clear and convincing evidence standard. And again, to Board Member Glazer's question, what's this term highly probable? I thought the standard was clear and convincing evidence. Well, as we're going to talk about here in a minute, that's another way that courts in our jury instructions, in fact, have described the standard of clear and convincing evidence. Is another way to say that very same principle is it highly probable that those facts are actually true? And then, of course, we have the beyond a reasonable doubt standard. That's the highest standard we have. It's a standard that is for, life and liberty. So we're talking about someone who may spend time, maybe the rest of their lives in prison. It's a standard that requires the government to prove a very high standard, what's also described as an abiding conviction that the charge is true. You don't have to be that you have no doubt whatsoever, but you have to be pretty confident that the charges are true. So that hopefully gives a little context. We're really in the intermediate place here for clear and convincing evidence when compared to the burdens of proof of preponderance of the evidence or beyond a reasonable doubt. So this is just a little more repetition of what we just talked about, but also I'll go quickly over it. But again, preponderance of the evidence is more likely true than not true. The intermediate standard, clear and convincing evidence, it's highly probable that the facts are true, and then beyond a reasonable doubt, an abiding conviction, the charge is true. So these are just a few quotes from some cases that talk all about the clear and convincing evidence standard. I mean, a couple of key themes of the clear and convincing evidence standard. It is the more elevated standard. As Toby mentioned this morning, when you're talking about a profession, a certificate, something like whether you're a doctor or a lawyer or a peace officer that's about to lose that property interest in the licensure that you have, they use a more elevated standard in government usually to prove that it is warranted to remove that person's license or certification. And so that is what the preponderance of the evidence standard is designed to be, is that more elevated standard. It's not the typical civil action standard. It's higher than that. It's an intermediate standard. It reduces the risk of error because it heightens the standard, increases the government's burden of proof. And of course, as we've talked about, it is another way of saying is it highly probable? If there's a high probability that the facts are as alleged, that meets that clear and convincing evidence standard. So I know we're going quickly. We're really on the last slide here for what I wanted to show you, but this is one last quote. It's a big, long quote from the California Supreme Court, but the upshot of the quote, and I won't read it here, is, again, we're really talking about high probability. The court here is talking about the fact that it's not, the clear and convincing evidence standard doesn't lend itself readily to definition. But again, what courts often go back to, what our jury instructions go back to, is it's another way of asking yourself, is it highly probable that the facts as presented are true? If they are, you've met that clear and convincing evidence standard. So I hope that's a helpful primer on the standard. I'm absolutely happy to take questions if we have any, but in the interest of time, I think that's about all we're gonna present to you today, unless there are questions.
All right, thank you. That was a great condensed version.
May I?
We have Dr. Glazer.
I'm not going to ask for clarification.
It's
I'm gonna-
okay. You could ask questions,
Well,
please do. Don't refrain.
I don't think this is probably not the time or the place to try to figure out what we think clear and convincing evidence is, but I'm just inviting the possibility that we could find the time and space for that discussion amongst the board. Because it could be anything, right now, all we know is it's somewhere between preponderance and beyond a reasonable doubt. That could be 75%, that could be 52%, that could be 99%. And I think it would be valuable for us to have some consensus on what we're striving for, or to have some kind of agreement that we're not going to have consensus on that. And
I think that's
try to do that.
That's a fair discussion to have at the board level. I agree. Thank you.
Thank you.
Thank you, Bryant. So Chris Becker is gonna talk about not the entire Bagley-Keene Open Meeting Act, because goodness knows none of us want to do that ever. But we do have to talk about a few things that seem to come up as themes, especially in this line of work. So Chris is going to cover those important factors of the Bagley-Keene Open Meeting Act that keep us out of trouble.
Okay.
You don't have to.
Oh, sorry. Is it on? Can everybody hear me?
Yeah.
Okay, perfect. So the Department of Justice, the Attorney General's office has actually put out a pamphlet on Bagley Keene, and it's really helpful and it's pretty thorough. So if you ever have a chance, you can go online, you can Google it, you can find it and read it, and there's a lot of really good information in there. But for today's purposes, we're just going to cover a couple of important aspects that come up with Bagley Keene. We're going to talk about serial meetings, and we're going to talk about closed session, even though Toby really did a great job of already talking about closed session. So the first question is, what is the Bagley Keene Open Meeting Act? It's a California law that covers all state boards and commissions, requiring that these bodies publicly notice their meetings, prepare agendas, accept public testimony, and conduct their meetings in public unless specifically authorized by the act. So Bagley Keene, for purposes of the statute, has defined the term meeting, which is going to be helpful for the next one as far as serial meetings. And a meeting under Bagley Keene is any congregation of a majority of the members of a state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject jurisdiction of the state body to which it pertains. And that's important because one of the things that we wanted to talk about today is that it's important to not create a serial meeting. So a serial meeting involves several individual communications which by themselves do not constitute a majority of the state body, but when taken together as a whole would. Specifically, the Bagley Keene Act states that a majority of the members of a state body shall not use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter of the state body. So there are two classic examples of serial meetings. You see them in front of you. One is the hub of a wheel and chain communications. So hub of a wheel is kind of what it sounds like. You have one party who acts as a hub and then speaks about an item that's within the body's jurisdiction with other individuals, which would be the spokes, to the point that a majority of the state body has discussed an item. Chain communications are sequential contacts among a state body's members. So you have A speaks to B, B speaks to C, C speaks to D, and so forth until the majority of the body has discussed an item within the body's jurisdiction. So those are two things to look out for. And only the second topic that I'm going to talk about is closed session. So a state body may hold a closed session not open to the public, but only for reasons expressly authorized by statute. And for your edification, these are covered in Government Code Section 11126. There's quite a few different exceptions, but we selected a few relevant categories for you today to talk about. The first is existing or anticipated litigation. A board may meet in closed session to confer with or receive advice from its legal counsel regarding pending litigation when discussion in open session concerning those matters would prejudice the position of the state body in the litigation. The second, which Toby covered in good detail, is deliberation following public hearing. And just, I wanted to give you the sites so that you could read them if you wanted to. This is covered under Government Code Section 11126 subsection 4, where it states, following the public hearing or closed session, the body may deliberate on the decision to be reached in closed session. And also this is contemplated in post regulation for the POSAAB board and for the commission. So post regulation 1211 subsection C says, in carrying out its duties pursuant to Penal Code Section 13510.85 subsection A subsection 4, the board may conduct deliberations in closed session. And for the commission, 1212B3, at the hearing conducted by the commission to review a recommendation made by the Peace Officer Standards Accountability Advisory Board, the commission may conduct deliberations in closed session. And the third example, which Toby also covered, but just wanted to cover again, is the administrative adjudications exception. So this exception allows a state body to meet in closed session to review and discuss an administrative law judge's proposed decision in quasi-judicial proceedings of the Office of Administrative Hearings. So essentially, like what we talked about earlier, when the matter would go before an administrative law judge for a hearing, and then the administrative law judge issues his or her proposed decision, that goes back to the commission and that can be reviewed in closed session. So the general rule is that there is no exemption for embarrassing, difficult, sensitive, uncomfortable, or controversial topics. Just wanted to highlight too, something that we talked about today is that under Penal Code Section 13510.85 subsection B, the division does have the discretion to redact certain documents and show them to the board and the commission in closed session. And then my last slide just has to do with the process for closed session. So the state body must publicly announce that they are going into closed session. During the closed session, a state body may only discuss the items listed on the closed session agenda. And following closed session, the state body must provide an oral or written report on actions taken in closed session, if any. So for example, and these were a couple of the exceptions that I didn't talk about, like employee and personnel matters and real estate issues and things like that, but these are just examples. So the board would come out and say, the board took action to dismiss employee 1, 2, 3, 4. The board gave direction to its negotiators to sell the property located at XYZ, and the board took no action on any closed session agenda item. So that's brief. There's a lot. Again, I would encourage you, if you do have a chance to look for the Attorney General's, primer on Bagley-Keene, please do so. There's a lot of really good information in there. If you have any questions, I'm here to answer. Okay.
Thank you, Chris. Who's doing conflict of interest? What's next? You want to do the ethical decision-making slide?
Sure, I don't know.
Okay, we'll roll with it. So this is really just to remind board members that you are required, I'll help you out, Chris, and put you on the spot. I'll move the slide forward. In terms of ethical decision-making, there's a couple of things that come up as board members. I'm going to go off script and just say two things. The first is all of you will probably at some point see a case where you know one of the parties involved, or you have information about the case prior to the case coming before the board or the commission. It is your job to self-police and to disclose if you may have a conflict of interest, meaning I have some inherent knowledge or relationship or something that may otherwise prejudice my decision in this case. On the board side, it may just be generally you have enough awareness of the case or the person that you feel like it's better to remove yourself from the decision-making process so that it's not questioned, because the entire recommendation or the commission's decision can be called into question if after the fact, the officer's counsel or any member raises concern around conflict of interest. So it's in the best interest of the integrity of the decisions made by both bodies that the person remove themselves. With the commission, if an employee or someone that was once employed by you or under your direct supervision or someone that you served with was a partner, obviously in those circumstances, it's going to be your discretion, but you have to think about the integrity of the process in the entire body, not just whether you feel as an individual, you can still make a fair and impartial decision. You may feel like that in spite of the relationship, you're very centered. You do have to consider what the optics are for that and make sure you're making a conscientious decision. And that's what board counsel's here to advise you is, hey, I want to disclose that I have this relationship or I have this knowledge of this case from my experience working in the law enforcement profession. I want to discuss it. You can discuss it with me. You can discuss it with Toby. You can discuss it with board counsel, and we can help you make those decisions if you need that kind of guidance. So that's the first thing I want to point out.
And Marie, let me ask you a little bit more about that. Certainly, so the situations you described were as to a person or an investigation. What if it's as to the issue? So what if the law enforcement officer is accused of having used methamphetamine or cocaine or was a drug addict, and the person themselves lost someone near and dear to them to drug addiction. So as soon as they see the words drug addiction, they have a visceral reaction. Whether they would vote one way or another, what should people do when they have an issue that they have a visceral reaction to?
And that's extremely sensitive because we all have experiences, right? And I think the reason that some of you, and we kind of had this discussion at the board level, the reason many of you were appointed to these positions is because of your experiences. However, if you as an individual recognize that your experience may cloud your ability to be objective based on your own emotional reaction to certain events or circumstances or incidents, we are asking you, you have to police that individually. It's imperative. Because if anything comes across, we talked about bias earlier from the subject peace officer side. We are also going to be in the public spotlight for imparting our own biases on these cases. And if that seems to not be objective or not be equitable, then our decisions can be challenged equally, as they should. So we have to do a really good job of policing our own selves in terms of our experiences and our ability to be impartial and to be objective, regardless of the experiences we've had. And that's a tough call for any one of us to make. But that's why I offer this as a discussion piece for today, is if you feel like there are things that you're seeing, viewing, hearing that make it difficult for you to be objective, please seek advice from counsel or myself so that we can try to help have that conversation and come to a respectful decision. So I appreciate you bringing that up. Are there any other questions around that topic? Okay. All right. There's a couple of slides in here. Doing a great job of being Vanna, though. If you want to stand up there and flip through slides, it gives me something to look at. There's a couple slides here about what we just talked about. I'm not going to read them to you, but I think these are just good reminders. They're in your material about questions to ask yourself. I think, Joyce brought up a good point is we have to conduct a self-evaluation of our internal mechanics and what's driving us to come to a conclusion, right?
I would like you to say a little bit more about that, because people can have a visceral reaction to something a law enforcement officer did. That, for lack of a better term, we'll call that, gee, anyone would feel that way. That's not bias.
Right.
As compared to the suggestion I gave you, which was someone lost someone near and dear to them to drug addiction. So can you help people kind of find that line between a human reaction versus a personalized bias?
Absolutely. And without being a psychologist, I can try to play one for a moment. There is a difference. We all have a certain reaction. If we think about use of force, or we think about an officer involved shooting, or we think about something where someone's life is taken, we all have a reaction to that in some fashion. That doesn't mean that we can't be objective about the facts of the case. But there may be circumstances where our own personal experience go beyond just viewing something and having a natural human reaction to tragedy that make it difficult for us to reason the facts. And this is really about how you reason the facts. And I'll say this and way off script, so bear with me. At the board hearing, I think we got to know some of the history of the board members right before we reviewed the cases, and we talked about what led you to want to be involved in peace officer accountability. But when we put facts in front of you and we gave you cases, there was very much a palatable display of equality and justice and trying to determine whether or not these facts in these particular cases warrant something as serious as removing someone's ability to serve in their profession for the rest of their days. And so you could see that even in spite of having some experiences that may have made you untrustworthy of law enforcement, when we put facts in front of you and you're looking at this individual, it was very clear to me that the facts were more important than anything that had happened prior to seeing that case on that day about that individual. And that's what it means to be objective and reasonable and assess every case for its merit. not based on a totality of circumstances that came before the case, right? And I think that's what we're hoping we get out of this process, is that every case has a unique DNA and a unique set of circumstances that we are going to regard as independent from anything that we may have experienced prior to reviewing that case. So I hope that was helpful.
If I may, in terms of the conflict of interest, obviously there's some circumstances in which there might be a financial conflict of interest, right? That's rare, probably rarely going to happen here. But what we're talking about in the context of the board and the commission and the circumstances that you raised, there are a couple possibilities. The one is that you in your mind know that because of your past experience with this topic, you cannot be fair and objective. And if that's the case, there's a conflict and you have to declare that there's a conflict and not vote on that matter. The second is the question that you always need to look at, and that is there going to be a perception? The public has to trust that the decision makers are making decisions and coming from the right place. So you have to look, even if you think, I can probably be fair, but I've made public positions, I've said things on this particular issue that are so strong that a member of the public might not trust that even if I have the best motives and the best intention, that I'm actually making an objective determination. And so that's another circumstance where you need to seriously consider whether or not you should recuse yourself and not participate.
Thank you. Thank you, Joyce, for parsing that out for us. But Toby, that's absolutely right. Sometimes it's just a matter of how the public's perceiving your ability to be fair. Something that happens if you recuse yourself is you can't attempt to participate. So it's not just the vote. You can't influence other members too, right? You can't pull them aside and have a conversation with them. It's beyond just actually weighing in the voting. There's often times where if you're going to recuse yourself, the best thing for you to do is leave the room while the vote's happening. So there's just no perception that you're making eye contact with someone trying to convince them to go one way or another. If it does happen in closed session, obviously you can't attend it because you're not part of the decision-making process at that point. So are there any other questions about, I think this was an important conversation to have because this comes up.
I just
It's
want to comment
relevant.
on the leaving the room part. If in closed session, we're on the record. So if you are in the situation where there is a conflict of interest, I think it's important to articulate for the record, I'm leaving the room.
Yes. Thank you, Joyce. It takes a village to close all the gaps. Okay, there are penalties for if you don't police yourself. I really don't know what they are, but I do know that the decision can be invalidated and it can also be challenged. I think it does say here that we can be prosecuted for that and that there's a $5,000 fine per violation if you're found to have a conflict and you did not recuse yourself. You could also, this isn't on here, but I've seen this happen in my experience with boards. This is definitely a reason for your appointing power to remove you from your service. So keep that in mind. If it's something that gets elevated to whoever was your appointment, whether it's governor, assembly, or senate, this would be grounds for removing you from participating indefinitely in the body. All right. We are going to now invite up our Office of Public Affairs. They are the folks that deal with all of the media inquiries, and the board's had a primer for this. And Katie and Megan are both really good at being succinct, but please feel free to ask them questions because they're here to really be a resource for you in case you do, and you will, I guarantee you, get contacted by somebody about a case or about something that's hit the media and they want information about what's Post is doing with regard to an act of serious misconduct.
Good afternoon. Now that we've told you that you cannot talk to your friends or talk to each other, Katie and I are now going to tell you that to please not talk to the media. My name is Megan Polis. I am part of the Office of Public Affairs with Katie Strickland, and we both serve as the public information officers for Post. And we are here to serve and help you in these types of situations.
All right. Good afternoon, everyone. So we're going to be pretty brief. This is kind of like a refresher of what we had at the last training. But basically, based off of the board's policy, if any board member, if anybody receives a call from the media, if you could just pertaining to the board or the commission, just promptly refer to the caller that, to the public office, I can't speak right now. Office of Public Affairs, sorry. And so you should just politely thank the caller and then state basically per our board's policy that we refer all media calls to the Office of Public Affairs. And at that point, the board member also per policy should email the Assistant Executive Director, which would be Anne Marie, and just indicating that you received a call from the media and put any important information that that caller supplied as well in that email as well. So if you have any questions, we have our email up there. The inbox goes directly to Megan and myself. And yeah, if you have any questions, please let us know.
Do you guys, or do you two want to take up the issue of telling people that you're on the commission, on the board, using that as part of your introduction, using that as part of your signature? Any of those thoughts?
I think what we have is not stating that you're on the board or mentioning anybody's names or anything like that, as well as not addressing cases, just to not mention any of it, I think would be the preferable route to take.
Yeah, and there's going to be times you're contacted because they know you're on the board, they know you're part of the commission, and that's why they're seeking information from you. Regina and I had a conversation the other day. Are you okay with me talking about it? Okay. So a sheriff from Ventura contacted Regina to talk about the process for what Post does with regard to serious misconduct, because the sheriff was curious about, hey, well, what are you doing with these cases and what happened at your board hearing? And so Regina did a really good job of referring him back to the website where he could actually view the case and he could see the facts, and reviewing him to information on the website about the process itself. And she did say, hey, I'm not the best person to answer all the internal procedural things, but I know people, and so I'm going to get you to the right people. So that's kind of what we expect. But the truth is, they're going to know you're on the board. They're going to want to contact you because they're on the board. They're going to want to ask you questions. What we steer away from is questions about investigation and also your personal opinion about the cases, right? Because that, if they publish that, obviously, again, what we talked about earlier kind of jeopardizes the integrity of you guys serving as a governance body. So, and the commission's probably already had this experience where it's not about serious misconduct cases, but they're contacting the commissioners about decisions that Post has made with regard to training standards or something that's happening in law enforcement with the use of force. You can answer those questions in your professional capacity as a chief, as a sheriff, as an undersheriff, whatever the case may be. We're just asking that, especially when it comes to what we're doing with the review of serious misconduct cases, that we stay away from the facts of the cases themselves and the personal opinion about where we think this case should go. And I think if we walk those lines, I think we're going to be okay.
The other important parts is either a commissioner on the hearing board is that there's no impression left that somehow you represent Post,
Correct.
or you represent the commission, or you represent the hearing board. Everybody has professional capacity and everybody has a personal relationship with their communities, but it's so important not to show that
Yes.
that's illusion, because it's not true. We don't represent Post, and I don't represent the hearing board, neither does anybody else. We're just members, and at that we leave it.
Thank you.
I wanted to add to that. I did one up on it. I invited Manny and his office to come down Ventura County to discuss what SB2 does, because like I said, I don't know what I'm saying, so we're in the process of seeing if he could meet with law enforcement and public officials. So that's one way of staying out of everything.
Thank you. The other thing I wanted to mention is the board actually, the Peace Officer Standards Accountability Advisory Board has a policy about this. So they went as far as to adopt a policy about not discussing these matters as a board member, and that would violate their own internal policies for kind of policing what they discuss outside of the hearing.
Thank you. And one more quick plug. Be sure to check out all of our social channels as well. Give us a follow. We're on Instagram, LinkedIn, Twitter, and Facebook. Thank you.
Oh my God, Katie, that was great. It's like an infomercial. Okay, Sarah, can we take 10? Okay, we're gonna take a 10-minute break and then we're gonna show you guys some video, so it'll get a little more exciting. You're not gonna hear anyone. Okay, folks, we need to get moving here. So we've got folks that need to leave and we want to make sure that we get this part. Does anyone have one of those whistles? I gotta get my gavel. There you go, man down. All right. Go ahead, Chandler. Do it. All right. Things just got real. It's coming off the rails now. Okay, so we are going to be wrapping up the training day. And what I want to do is kind of leave you with something that I think is going to be useful from the standpoint of the types of things you're going to see when you're rendering decisions and recommendations in these cases. So I'm going to introduce Jim Katapodis. Jim Katapodis is a law enforcement consultant at Post, and Jim is a recognized use of force expert. He has testified in over 200 cases, both federally, the state level, county level, and he's reviewed over 892, did I get that right? Reports of excessive use of force. And I think what's important is that we have this internal expert that we can use and call upon when RBCs are meeting and they're discussing a use of force case and they want to bring in someone that has this kind of expertise and experience. Jim is always willing and available to take a look at the cases, and he does it for free for us, which is super helpful. I mean, I think we pay him a salary for something else, but I'm not really sure what he does outside of help POSAAB. So today he's helping POSAAB again. And so you're going to see a video that's not from California. And reviewing, Jim's going to talk to you about some of the circumstances of this video that would be very relevant if it were in California, and things that both this board and the commission would need to assess in making a decision about how far we go with the imposition of discipline and whether or not we think something went seriously wrong. So without further ado, Jim Katapodis.
Thank you, Anne Marie. I appreciate that. Yes, please. So I have a little handout here, a little homework for you. If you have it in front of you, it's going to be a lot easier. So we're going to see a video, but I want you to take a look at a couple of things. When I look at a video, and I think Toby said it earlier, the video is just a video, but usually like an officer-involved shooting is about 5,000 pages of documents to read. And so there's a lot of documentation that goes with it. However, today, you're just going to take a look at this video and kind of dissect it a little bit. So when you're looking at this video, I put in here 835.4 of the penal code in here, just so that you can think about that, because I think in most of your decisions, at least for this one, because it's not deadly force, but, and maybe I'll just read it out in the record here of that the decision by a peace officer to use force shall be evaluated from the perspective of a reasonable officer in the same situation based on the totality of the circumstances known to or perceived by the officer at the time, rather than with the benefit of hindsight, and that the totality of circumstances shall account for occasions when the officers may be forced to make quick judgments about using force. So when you look at this, and I never look at a video just once, and you probably won't either. I look at it like as many times as I can and try and pick up the nuances of everything. But as you look at this, part of looking at the use of force is what kind of crime do we have? Is it a serious crime or not? So take a look at that. Just keep aware of these things as the video is going on. Do the officers have a plan? What was the officers' communications between each other? Is that significant? You'll notice that the officers knock on the door. Did they identify themselves? Do they have to? Let's take a look at that. Was it reasonable for the officers to draw their weapons?
what level of resistance did the suspect display? And anytime did the officers provide a warning of the suspect? Were they required to? What was said on the radio after the use of force? Why did the officer move the edge weapon? We'll call it an edge weapon because we're not really sure what it is. It looks like a sword. It looks like a sawfish, something like that. But let's just say edge weapon into the hallway. Was it appropriate to handcuff the suspect after the use of force? And was there a duty, we talked today about duty to intercede. Was there a duty to intercede by the partner officer? And if there was, when would that have happened? So right now, we'll take a look at the video, and there's some language in there, so I'll just warn you right now. And it's, you probably can see it on YouTube, but this is the video right now. Chris.
No. I'm here. I'm Tim. This is Brittany. That was the neighbor right there. You're the ones that called. Wait. This is Brittany. She's the one that got hit. I live here. This is my friend Brittany. And then this is my neighbor that hit her. I wasn't even here. I was outside. She's on the phone to be fair.
Which one? Which?
Okay. This
Alright,
neighbor
thank
right
you.
here is what she said. Like I said, I wasn't in here. I literally just saw.
Banged on the door, like, or through the wall. Bam, 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 and I'm sleeping. Shut the fuck up. And so I like came out and was like, what's going on? He wasn't here. Dog wasn't here. Okay, and then what's it So look I like? came out and I was like, what's going on? Right to the fucking mouth. Okay.
Okay, now which room is he?
I don't know, right there, possibly.
Okay, what's he doing?
He is an older man. I honestly don't know. When you get knocked the fuck out, you don't really.
We just moved in from this. When did this happen? 20 minutes, 15? I called.
Not even.
Yeah, not even. I called I walked in the door and
He busted all my shit, my nose, my mouth. All I wanted to do was like, hey, what was disturbing you? And he was like, shut the fuck up. Boom. Was he white, black? He's Hispanic? white. Does he have hair? Yeah. Bald? Gray hair?
yeah, gray hair. He's an older guy. He's about this tall. That guy lives right there in that room, and that's where the wall would go.
And he was bang, bang, bang. That's what woke me up.
We just moved in here yesterday, but I saw him last night.
Okay.
I'm gonna put my phone in the bathroom, okay?
Okay.
What do you want? What the fuck? Motherfucker over there. Put it down, motherfucker.
Put it down!
Put it down.
Get on the ground down!
Back up. Get out here right now. Get out here.
Get on the ground!
No. They hit that wall so hard, I thought they were gonna come through the wall. What you gonna?
Okay. Part's unconscious.
There was 7 taser deployed. Party came out with a machete.
Hard to inform. Did you catch any of our traffic?
Yeah, they just got us taser deployed.
You start an ambulance.
All right, let's get him set up. Yeah, I got it off. Sir, 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 talk to us. Talk to me. Talk to me. Sir, talk to me. Sir. I got him.
He's breathing, he's fine.
Okay, stay on your side. Stay on your side. Stay on your side. I'm police. I'm the police. Stay on your side.
These are my walls.
I understand.
I have my walls.
I understand, sir.
Aye. Aye.
Stay on your side. Stay on your side.
There must be a big party.
Okay.
Do you remember anything that happened?
I was playing there. There was a big bang on the wall. And it literally moved my head.
I understand.
Couple of days.
We need to stop here.
And then
Okay?
I pounded the wall.
Okay.
I told them, knock it off. And I was doing nothing except laying there sleeping.
Okay.
And
Charles,
They
talk
were-
to her.
and they were banging to the wall. I mean,
Are you good?
loud.
Are you okay?
And I thought it was them going after me.
Hey. Hey, my name's Ellie. Sorry. How can I help you? What's going on?
She's been drinking.
Okay, I get that. And that part
It
makes.
doesn't even matter. That's my own fucking thing.
Right, yeah, no, that's not your
When I
fault.
have somebody bang on the wall and they fucking punch me in my fucking face.
Right.
Because I asked him, am I being too loud?
That's why we're here. I'm here. We're here for you.
Yes, ma'am.
Okay, so what's your name again? What's your name again?
Brittany.
Brittany, my name's Ellie, okay? You're okay. You're okay, all right? Are you okay? You're upset, I get that, but are you okay? No, what can I help you with? What can I help you with?
What I want, and I know it's totally illegal, but I want to kick the living fuck out of him.
Okay, well,
And I walked away like a dignified human being and came in here and I tried calling him and was like, I just got fucking knocked the fuck out.
okay. You're safe now. Things are okay. I know it doesn't necessarily like make it all better, okay, but we're here.
This is Brittany. That was the neighbor right there. We're the ones that called. Wait. This is Brittany. She's the one that got hit. I live here. This is my friend Brittany.
there.
And then this is my neighbor that hit her. I wasn't even here. I was outside. Okay. She's on the phone to dispatch it.
Okay.
This
Alright.
neighbor right here is what she did. Like I said, I wasn't in here. I literally
He
just saw.
banged on the door, like, or through the wall. Bam, 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 and I'm sleeping. Shut the fuck up. And so I like came out and was like, what's going on? He wasn't here, dog wasn't here.
Okay, then what's?
And so I came out and I was like, what's going on? Right to the fucking mouth.
Okay, and which room is he in?
I don't know, right there, possibly.
Okay, what did he look like?
Is an older man. I honestly don't know. When you get knocked the fuck out, you don't really.
We just moved into this.
When did this happen?
20 minutes, 15. I called.
Not
I'm at-
even.
Yeah, not even. I called like. Where do you hit it?
He busted all of my shit, my nose, my mouth.
Okay.
All I want to do
Bro,
is like, hey,
was outside.
what was disturbing you? And he was like, shut the fuck up, boom.
Is he white, black?
He's
Hispanic?
white,
Does he have hair?
he had
Bald?
gray hair.
Yeah, gray hair. He's an older guy. He's about this tall. That guy lives right there in that room, and that's where the wall would have got.
He was bang, bang, bang. That's what woke me up.
We just moved in here yesterday, but I saw him like last night. I'm gonna put my phone in the bathroom, okay?
Okay.
What do you want?
What the fuck?
Put that motherfucker over there. Put it down, motherfucker. Put it down. Put it down. Get out here.
Back up. Get out here right now. Get out here.
I hit that
Get on the
wall.
ground.
No. They hit that wall so hard, I thought they were gonna come through the wall.
Put your gun away.
Cards unconscious.
Two of 17 deployed, current came out with a machete.
Prior 204, did you catch any of our traffic?
Yeah, they just got us taser deployed.
Okay, we have him in custody. Can you start an ambulance?
All right, let's get him set up.
Go ahead and turn that off.
Yeah, I got it off.
Keep him.
Sir, talk to us. Talk to me. Talk to me. Sir, talk to me. Sir.
It was him.
I got him.
He's breathing. He's fine.
Okay, stay on your side. Stay on your side.
Hey,
Stay on your side.
ain't an ambulance coming. But you're okay.
Yeah,
right.
yeah. She been, yeah.
Yeah, we're good.
That was like a while. Hi.
Stay on your side. Stay on your side.
They must be a big party.
Okay.
Do you remember anything that happened?
I was down there. There's
Okay.
a big bang on the wall. And.
Hey, Brittany, I understand you're upset, but you need to stop too. Okay?
On the wall.
Okay.
It's gonna knock it off. And I was doing nothing. Laying there sleeping.
Okay.
And
I'll go talk to her.
Okay.
they were banging on the wall, I mean, loud.
Are you okay?
Yeah, I'm good.
And I thought it was them coming after me. These people were I mean, officer, I was just. These people over there they hit my wall hard. I thought they were coming through it. You know that?
What's that?
They hit that wall on my there. I thought they were coming through it.
Okay, all right. All right, here's, what's your name? What's your first name?
Mike.
Mike? Okay, you're under arrest right now, okay? So you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney and have him or her present during any questioning. You can, if you cannot afford an attorney, one will be appointed to you by the courts.
What action is gonna be taken over there?
Okay, do you understand those rights?
I understand those rights.
Okay.
All right. Interesting video, right? What was the crime? Remember, what was the crime that they were investigating? What? Assault. Yeah, simple assault, right? And I think the next part was, what about the communications with the officer? I always look at that. What about the communication with the officers before they went to the door? None, right? None. None. And this is like a training officer and a probationary officer, right? So no communication, just go right over there. So they didn't identify themselves when they knocked on the door. Is that a requirement? That's the right answer. So it's not against the law. It's only for search warrants, basically, to that you would then knock and notice. However, a lot of agencies have it in their policies already. It says that you shall identify yourself. So the policy might have it, but California state law does not require it. That's exactly right. Was it reasonable? Yes, ma'am. Taser. Well, electronic control device, actually, technically.
I don't like this. I'm not a police officer. Is there number of times they have to ask him something? Because that was the part that kind of caught me was he's explaining, he put the machete down. Looks like even though he said no, I'm not coming out. Shouldn't there have been something else to let them know, if you don't do this, then this will happen, or you just tase them?
Board Member Lara, I see you wanted to say something.
Again, it is good practice to advise people what is coming. So if you, I'd really like, I would like to get you to comply. Here's what may happen if you do not comply. But there's also factors about what level of resistance is he showing, and is using the taser appropriate in the first place?
Right. And I think your question is, we do with this thing called de-escalation, right? So de-escalation is important, and we teach that in California, that officers are supposed to de-escalate a situation when they have the opportunity. And the question is, did they have the opportunity there to de-escalate? And I see you're shaking your heads, yes. So yes, they had the opportunity to do that. Do they need to provide a warning? Now, some policies say that they shall. So some agencies, you'll see that when you get the paperwork, it'll say they shall provide a warning. A lot of agencies have that before they use a taser when feasible, right? So when feasible. So obviously if someone's attacking them or something, they can't give them, but they can do it. In this case, you're absolutely right. What about drawing their weapon? Is it okay to draw their weapon when they see somebody that has we'll just call it a edged weapon again, because it's an odd looking edged weapon. That's what it is? Thank you.
So yeah, it's from the, or at least from the islands, Pacific Islander. Yeah, if it can, if it's from the Pacific Islander, it's a weapon that they use like shark teeth and stuff. And it causes great bodily injury. But yes, if they believe that there's a threat to themselves, right, that can cause great bodily injury and death, they can pull out something that's lethal force. But I need to go back because I think we're gonna be looking at a lot of stuff, and this is my third agency now. And here's what I can tell you about agencies, the policies. You have to look at the policies, and you have to look at what training do those agencies provide to those officers. Because we may look at it and say you came from an agency that has great policies and a lot of stuff. You may look at it and say, this is a no-brainer. We should do A, B, C, and D. But when you start digging and get into the gray areas, that is the harder part. And we have an obligation to look at that. Because maybe we're not gonna impose whatever because the agency didn't do a good job. Now, that doesn't relieve the agency of the civil stuff that's gonna come along. They're gonna get dinged on that, but, we're looking at the livelihood for, people that are peace officers, and so I think we have an obligation to really take a hard look at those things. Now, having been with my third agency, and you're like, it's not all the same.
It's not all the same, and there's the law and then there's policy, right? So we follow the law and the objective reasonableness. We talked about that in the beginning in 835, right? It has to be objectively reasonable. And I always say, given the same set of facts and circumstances, that officer at the time, would a reasonable officer have done the same thing? And if you think of that, what's the answer to that question? So definitely drawing your weapon, correct? That's an edge weapon. It can cause, a serious bodily injury, right?
I
Yes.
guess my question
Board
is,
member.
it appeared he had his weapon out before they knocked on the door.
Right,
So he did have it out before he knocked on the door.
he did.
Right.
He did.
Okay.
Just, why did he think he had a weapon out? You said it.
Sorry, because what he had just gone through with the neighbors, and they didn't announce who they were, so he didn't know who was at the door.
Very good deduction there. I would say the same thing, is that he believed it was the neighbor coming over maybe to beat him up or something, so he armed himself. But as soon as the officers gave him
Yeah,
direction.
maybe you misunderstood the question.
Yes.
The officer, I thought, had his weapon out before
Yes.
he knocked on the door.
Oh, no,
He did. It was
no,
something
he had a
black.
flashlight.
Oh, that was his flashlight.
I've seen it more than once.
Oh.
In fact, I had to look at that myself. So I totally agree with that. I looked at it myself and said, did he have no, it's a flashlight, but then he did pull his weapon and then he put that away and went for the taser. Yes.
I actually was wondering if her story was accurate. Like, one of the first things I wondered was, did the neighbor do that, or did the boyfriend do that, or somebody else do that?
So I think it's a good question. And the question goes back to, did they do a thorough investigation before they knocked on the door with her? Did they get all the information, like you said?
I think so, because the boyfriend kept saying, I was outside.
I would have said that, I'm sorry. If I was a boyfriend, I would have said it too. Clearly, remove me from it.
Well, yeah, I think you're right. I think they could have done more investigation. I mean, it was like, a couple of seconds of, hey, what happened? I got hit. And then him walking over there, knocking on the door. Yes,
A simple question to ask would have been, were you making any noise?
right.
And, she said I was sleeping, but then it started to sound like maybe there was noise coming.
Right, because she made noise earlier. I mean, later on, she made a lot of noise too, right? Yeah, so I think that's a good point. I mean, I think the investigation itself was flawed, right?
Well, it seemed like the officer just precipitously suddenly walked over to the door, banged on it pretty hard.
Exactly. Didn't communicate with his partner. She didn't know what he was going to do. She just ends up running over there. But then we go back to, it was appropriate for them to draw their weapons because he has an edge weapon. Serious bodily injury, right? Because extensive suturing, serious disfigurement, if that can happen with that tool, then that's something that we say you can use deadly force to protect yourself. Well, once he puts it down and he stands there, we go back to kind of what you were saying. He stands there and he's in boxer shorts. Not like he looks like he's hiding any weapons. No. So he's not hiding any weapons. So what was his level of resistance there? What do you think?
There was a level of resistance because they asked him to come out and he said no.
Didn't they say get on the floor?
Yeah, they said, get on the ground.
He
I just
said
remember
no.
him saying no.
Yes, he did say no. So yes, he did refuse to do what they want him to do, get on the floor. But then what happened after that?
Just talk to him, at least ask him what happened. They didn't really ask him.
Nice.
And he was kind of giving the mirror story that she gave. Just the opposite. According to him, they were coming through the wall. I mean, it kind of sounded like something was going on in that apartment that was pounding on the wall. And that we all know what that could have been. And then it irritated him and he yelled and then I don't know what happened after that.
I don't know what it could.
We don't know.
I don't know what it could have been.
Well,
Let's not go there. We don't know what's going
Right,
on.
but more importantly, I think that caught me was, yes, maybe they should have did a more thorough investigation. But he basically admitted to the fact he assaulted her. And that's where the charges are gonna be.
he did?
Well, he was talking about how he went over there. Did he say that part?
I didn't hear.
He didn't exactly admit, no.
Okay.
But still, but the question is, was his resistance level, the level of the use of a electronic control device, better known as a taser? I mean,
Back to policy. Because he's not compliant. And I know you can go, oh, that's horrible. The tactics were horrible and this is horrible. But then you look, even with all their horrible tactics, when they got to this point, and the case law is changing that, but when they got to this point, was it reasonable? Was it objective? Unless I'm looking at all the policies, I'm not gonna know what that agency, what their culture is in that agency. And that sounds horrible to say the culture, because we want everybody to be the same. But that's not what we're dealing with. And I think we're gonna see that with cases as we move forward.
yeah, I mean, some agencies had before uncooperative use the taser. They had it in their policy. I don't know that they have it there now because I haven't looked at all the policies in California, but the question is, was it reasonable? That's the real question, objectively reasonable.
So I would say, I'm not sure what year that occurred, but also you're saying it's not in the state of California, so this probably wouldn't apply. But in the state of California, in 2019, AB 392 was passed. We changed that reasonable standard to necessary standard. So they had an obligation to de-escalate prior to using that taser. So just because he said no, did not justify using the taser. They could have continued to talk to him to get him to reasonably respond. He didn't approach to attack. He gave no inference that he was going to do anything harmful to them. He just said no.
Excellent. And I did hand out 392, so you'll have it there.
Oh, okay.
So I'm glad that you brought that up because I did have a handout for 392. Yeah, was it necessary? And that's what you're all going to look at as far as that goes. What's the law? And we look at policies as well, but it gets down to whether it was objectively reasonable, right? So a good discussion on that. What about what about him taking that edged weapon and putting it in the hallway? What did you think about that? He picked it up, he put it in the hallway. You can't see it, but he took his phone out and took a picture of it in the hallway.
Under what authority did he enter a place where an expectation of privacy exists?
Yeah, I mean, that's a good point. But why was he putting it there, taking a picture?
I tell you, on the audio, it was stated that he had a weapon and therefore the taser use was justifiable. However, he actually put the weapon away. The weapon then was brought outside of his home and basically laid on the ground. So we don't know what was in the investigative written report, but it's possible that that can give inference that he actually had the taser in his hand at that door before he was tased.
Yeah,
Or the
excellent.
weapon. I
Yeah,
meant
the
the
weapon.
not the
You're right.
Yeah.
You're right that he was in the hallway with the weapon.
Yeah.
And like you say, that's why the documentation, that's why you can see a video, but the documentation is so important because, that's the other piece of the puzzle that you need, because what was his reasoning for that, taking that picture of the edged weapon out there? I mean, on the onset, it doesn't look very good. And then his partner said on the radio, I tried to make you pay attention. It's kind of quick, but when she said, subject been tased, he came at us with a machete. Is that what happened? Did he come at them with a machete? No, he didn't come at him with a machete. So does that go back to part of this dishonesty? I don't know. That's something to look at because the body cam doesn't show that.
So that's that is blatantly dishonest. And although this happened in, oh my God, Trey Nichols' case, where the officers, well, I guess it's called, we call it cop talking. They were like, oh, did you see him? He came at me. He was swinging. He was belligerent. But when you looked at the film, they weren't doing any of the above. And so it goes to the point of this one, you know, somewhere in the culture, you know, with body cameras, we're seeing officers kind of playing out their narratives of evidence and saying, well, you know, he had this, so that is for the record. But as we all stated, he didn't have it in his hand.
I think officers forget.
That is dishonest.
But Jim, I'm gonna play the devil's
Go ahead.
advocate again.
Yes.
Most of you guys didn't know what kind of weapon that is, and officers come from the same street. I just read a lot, so, you know, so I knew what that weapon was. But your average officer probably doesn't know what that is unless they deal with Pacific Islanders and they go to Hawaii a lot or whatever. And that, until you read her statements, why she said that, to her, it may be a machete or maybe machete-like. Man, how would you describe that? Right? If you're somebody who just, that's the first time you've seen that kind of weapon. So I would have to read the statements like, well, why'd you call it a machete? Good investigator would ask those, but I would have to know those reasons.
Yeah, I think,
I
I
guess my
didn't know what it was.
concern was,
Yes.
that whether it was a machete, a large knife, or whatever, it was point that they said he came at them when in fact he didn't. That was what we were picking up.
Yeah, that's the issue. I mean, it's the issue. She said she came at us. It's exactly right, Board Member Crawford. I'll get everybody's name by the time this is over. But yeah, I mean, that's the issue, is that they came at us. But I mean, I'll go back to what.
Jim, I'm playing the devil's advocate again, so
Yes.
sorry. Because we're seeing just a video where they're saying very short things on the radio. Look, I wouldn't have tased the guy, even as a young officer. I would just said, and I would have talked him up, put it down. But we have to read all the other statements because coming at them could mean it's at your side, right? It takes split seconds for a weapon to be dangerous again. And you know, our peace officers are taught that. So it's not only just the video, watching the video, but also what's the state of mind for the officers? Is that state of mind reasonable and objective that any officer with the same training, amount of whatever, would make those kind of same decisions? Like I can come at it because I've got 35 years. I'd be like, hey, just come out, you know, and you talk to them. But again, it's a case by case and with everything. To me, it's always a case by case.
Yeah, and I think that's an excellent point, Commissioner, because in a statement, she could have been talking about when they first opened the door and it appeared to her that he was coming at them. So it's an excellent point that you make. That's why documentation is important, right? So yes.
To that point,
Commissioner
actually,
Lewis.
what they did was they rushed in when they saw it. Remember, the officer started swearing at him and kind of went in when you would think that if they were concerned about the danger of that weapon, they would have stood back.
That's an excellent point, because I think tactically speaking, most law enforcement people say, okay, you see somebody with an edged weapon like that, you don't rush in the door, you back off instead. And that we talk about that in 392, it also talks about distance, time, distance. Are you able to have time, distance? Can you redeploy? You know, and we don't know what their policies are. We don't even know what the state of Colorado does, but still, excellent point on that. That you have to look at time, distance, and do they have time to do those things? They have time to de-escalate that we talked about. They have time to talk to him. Well, in California, we would hope all this de-escalation training that most law enforcement officers would understand that, and also in their policy. See, I miss anything? What about the partner? We talked about interceding, right? So we talked about it earlier today. I think, was it Christine that talked about it? But interceding. Did the partner, should she have interceded when he used a taser?
Jim, I can't see that she had opportunity to. There was no warning, the communication between the two was terrible. They didn't pre-communicate, they didn't communicate during the incident. He's saying, come out, she's saying, lay down, he's saying, come out, she's saying, lay down. They're not talking to each other, they're both talking at him. And then all of a sudden, boom, he just tases the guy. She didn't have an opportunity to intercede. She does have opportunity to be truthful about telling what happened, but she didn't have opportunity to intercede, in my view.
Yeah, I think you're absolutely right, Commissioner Braun. That's exactly what, she didn't have time to do that, but she does have an obligation later on to report exactly what happened and bring that forward, which is still a part of interceding, right? So that is important that she do that. Yes.
Positive that she rendered aid and made sure that he got on his side since he was having problems breathing.
Yeah, she was good at that. I'm not sure about her partner.
I don't think.
He's breathing. He's okay. I'm not sure that's the right statement to make on that. It's an interesting comment there.
Yeah.
Yes, you're absolutely right. She did do that. I think she was starting to become concerned about the whole situation.
Yeah, I was gonna add, about the interceding. They didn't give him a chance to be defensive enough for her to consider telling her partner, we may not need to tase him, some kind of form of intercede. So that never got to that point or level, I believe. But also, it was interesting that Tina shared, we don't know what was in the policy, and because I haven't read, I'm sure not near as many policies have you read, but it just seems like common sense would be that you don't tase a person that's not attacking you. Just because he said no, didn't, to me, warrant a justification for tasing. Now, it may be written in policies that if a person says no, you can tase them. Now, if it's in a policy, to me, that's bad policy.
And I don't think it is in California. I'm just telling you right now. In fact, if you look at Learning Domain 20, which is our use of force, right? It says that you give a warning when feasible. It also says you have to alert your partner that you're going to tase somebody.
Right,
So none of that was done.
So
I don't think you're going to find that in California.
to Commission, Tina, policy is key. We are not law enforcement, we're not attorneys, but a lot of things that we do in our training and what we do, we look for policies, procedures, and practices. So we're constantly looking at that to see if it goes along with what the officers did. And this probably in this case would have played an important part in deciding what are they trying to do? Decertify them or suspend them? In this case.
Well, I already know because Anne Marie told me, but he gave up the certificate, so they didn't get that far. But when we look at you have to look at the law, right? You have to look at Graham v. Connor, right? The objectiveness reasonable rule. Would an officer in the same situation, given the same set of facts and circumstances, would they have done the same thing? Because even policies, which I seriously doubt any California policy has anything that says it's okay to tase somebody when they say no. I seriously doubt that because all our training materials don't say that.
Right.
So that's what you're going to look at the law. Ultimately, you're going to look at the law. And the law is 835A, it's 392, it's, that's what you're going to look and examine. So when you're looking at something like this, you look at
Again,
those.
playing
Yes,
the devil's
Commissioner.
because
Yes.
you mentioned that he was the field training officer and it was a rookie. So, when you're looking at what would somebody think, you would also have to look, what would an FTO think versus a trainee, right? It's different. So that's probably why he gave it up, because I'm sure he did all kinds of things against their policy that he is held to a little higher level because he is a field training officer. So he has an obligation to understand all the policies a lot more than the person who is one day out of the academy. So.
Do you have something, Anne Marie?
Well, what I wanted to do is kind of circle back the reason why we showed the video and why Jim's asking these prompting questions, which I think is really important, is what things should we be paying attention to when we're reviewing this type of evidence? And you guys are doing exactly that. And that's why we wanted to have the exercise, is asking all the right questions about what we should expect to see, what didn't happen that should have happened, and then how egregious was what didn't happen or what did happen that shouldn't have happened. I think just to close the loop on this, the officer did surrender their certification. The partner was terminated, failure to intercede. The victim in this case, that being the elder gentleman, sued the agency for $7 million and was successful in that lawsuit, suffered long-term ill health effects, could not live independently after this particular incident. And so I talked to the executive director in Colorado about this case, and this case was an interesting case for them as well, because again, it didn't go through their full adjudication process because in fact the officer surrendered. But it was a case that they thought was a great training tool, because while their laws are different than California, the fact that the officers did not identify themselves and, arguably probably escalated the situation. Mike Radford and I were talking about it, and something Mike was going to bring up is he went to the door and he's pounding on the door, right? We don't know what time in the morning. I don't remember if there was a timestamp on the video at this point. Was there? That's why you're a cop. That's why you're a peace officer. So someone pounds on your door, right? That late at night, aggressively. You might grab something to arm yourself because you don't know what to expect on the other side of the door. Right, you've had an altercation with the neighbor.
Altercation prior to that, that prompted the initial radio call. And we're not really sure at this point what really happened in that first incident.
So these are all the things when we talk about the Graham versus Connor and the totality of the circumstances and all the things that we look at in addition to just very, black and white violations of law that really come into play in terms of why you make the decision you make and the imposition of discipline that you think is appropriate. And I think Commissioner Nieto brought up a couple of good points. How seasoned is the officer? Should they have expected to know? And that does play into our decision-making. So we just wanted to kind of condition you with these videos because you're going to see more of these in the use of force cases. There's usually always body worn camera or dash cam or something that you're going to see, and that plays in large part the evidence. There's other things that tell the story. And I think we talked about that at the last board meeting, that we have to keep in mind that we don't rely solely on the video. And Jim, in your experience, I'm sure you can recount how many times the video may have persuaded a jury to rule one way, but after they heard testimony from the officer, testimony from witnesses, they read reports, that it's a very different story because it's never going to look good. And that's not to be, missed in this whole discussion.
Yeah, I mean, I go back to what Commissioner Nieto was talking about as far as that goes. I've seen videos that looked really bad. And then just like you said, Commissioner, I would look back and I'd see all the documentation of what happened before, what the officers knew at the time, and it just changed everything. But yeah, sometimes the video is really not good, but then you take a look at it and you look at the statement. So, I kind of wanted to walk you through the seriousness of the crime, the communication of the officers, because when I look at a video, I try to dissect every little piece, because just like Anne Marie's saying, like Mike Bradford said back there too, it's the totality of circumstances. Is it against the law to knock on the door and not announce yourself? No. But was it a contributing factor to everything that happened? The answer is yes. So it is something that you have to pay attention to, even though it's not against California or state law or federal law. It's still a contributing factor to how this whole thing came about, right? And how this use of force happened.
To Sheriff Ingram's point, I'm disappointed that they terminated the officer, because I don't think that she had time enough to de-escalate the situation. And given right now, you're hearing agencies having a hard time hiring officers, and I think that she probably would have been a good officer. And to be so quick to terminate her instead of training her, perhaps suspending her. But that's always a greater concern because we do need good officers, with the correct training. And everything that you're telling us, I just kind of feel like maybe if officers knew this, maybe their approaches would be a little bit different.
And this is probably one of those duty to intercede after the fact, not during the fact, maybe more. I'm not quite sure of the facts, but what
Well, and
happened?
there was dishonesty in there too, right? So remember when she calls it in and he has a machete, and then I believe her incident report was not accurate. So there was other factors. Yeah.
It should be noted too that in the law, we hold the standard to the brand new officer and the seasoned officer to the same standard when it comes use of force. We can't just say, well, I'm new, so I shot him, or I'm new, I used the taser. That's not going to work. So we hold them to the same standard, whether they've got 5 minutes out in the field or they've got 20 years out in the field. They have the same standard. So keep that in mind as you look at all these uses of force, because they're held to the same standard. They've been trained, they have all the information, and they might make some mistakes, but they can't make a use of force mistake like that.
I want to make
Board Member Laura.
three points. So the comment about policy, absolutely. I bet they got a new policy after this incident. So that's probably, they're moved to a different policy. But I think about present capability as part of the calculus of what an officer does. He did not look like a particularly spry person, and he did not have a weapon. There was clearly no place that another weapon was going to necessarily be hidden on him. So the calculus of present capability, was, I don't know that was met. PC 844, although not legally required, one of the reasons we give a PC 844 warning before making entry, knock and notice it's known as, is that we want to not have a violent confrontation. Like if the drug dealer knows it's the police, not the rival drug dealer, they may be less inclined to shoot through the door. And so as a matter of good practice, hey, it's the police, or whenever I'm waking up a person who's drunk, hey, it's the police. So if I get punched in the nose, that they know ahead of time that I was the police. So that reduction of violent confrontation being a good practice, even if not legally required. So all those, and then this, I think that about covers what I'm thinking, but it just, those things go way into the balance.
Absolutely good points. But like Anne Marie says, it's all about how you start to dissect these videos, and you have to start at the very beginning. What was the crime? How did they investigate it? And you're all very good about that. So you have to take a look at how they investigated it. What did they do? And then communication between the officers, did they have time to de-escalate, which they're supposed to? Was it necessary? All those things have to come into play.
And I was curious, where did the prongs land on him? Because I thought it landed near his groin area. That's what it appeared to me.
It did appear that way to me too. I mean,
So that was an intentional shot. Aim.
that I don't know. That could be in the documentation, but yeah. Yeah. The guy was 75 years old, so yeah, he had a stroke and a heart attack after that, so. But definitely age discrimination right there. 75, shoot him with a taser. Well, is age a consideration, right? Age, physical ability is part of the law, right? You have to consider age, physical ability, size of the suspect, how many officers are there, and and what the suspect can do. And I think you're right, looking at him, he doesn't look like too much of a threat. So not in that outfit either. So yes, come in, board member.
Yeah, I really didn't, believe the woman in the very beginning. Didn't they have an obligation to talk to her more or investigate a little more? Get more of the story or ask him the story? They didn't even ask anything.
Yeah, I mean, 100% that you're right, because we talked about that investigation. It should have been a lot more than that, right? So it's a totality of the circumstances, and that's another piece to it. right? It's another piece to consider. 100%. Okay, anything else? All right, well, thank you for your time.
Thank you. Oh, good.
No, sorry, quick Google search. She received a written reprimand for that incident, but she and that partner had another incident where they tackled a deaf man because he walked towards them. And then she ended up resigning. So,
Yeah, she was terminated. Well, thank you.
yeah,
Thank you for Googling that, Ingrid.
it's a habit.
How many more times, probability? But she feel like she's gonna go on.
Yeah.
All right. Well, Jim, thank you very much for that review. And I think that was helpful and we're going to do more of these. This really concludes the training for today. And what I hope you got out of it is, again, stages of review, administrative review on the appeal, what things we need to consider, why the parameters are what they are. But it brought about some very important discussion that will continue to flesh out. You all know what the gaps are. I think it's clear, right? We all know that there is areas that are still unaccounted for. Let's just say that. And as we walk through these cases, we may be bringing things back to the commission from a policy consideration that we need to close the gaps. And that's what we are still working to do as we move this process through to full adjudication, which is once we see what happens with the ALJs. A couple of quick notes, and then we're going to let you get out of here. Toby and I are going to be participating on, I believe it's March 14th. We are going to be training the administrative law judges on decertification of peace officers. So the Office of Administrative Hearings has invited us to do the training for the judges since they are not familiar with the law and the provisions surrounding these interesting hearings that we have, the prelim hearings and then the final ALJ hearing. So that will be helpful. And then also, as I mentioned before, looking forward to publishing some disciplinary guidelines with the commission's review. Are there any outstanding questions before we turn it over for just some logistics? Yeah. Mr. Johnson.
I heard March the 7th, also heard March the 21st. And then I did hear April earlier.
Yeah,
So could,
let me clarify.
yes.
Okay.
Okay.
March 7th, 6th and 7th actually are the commission meetings. And those are going to be webcast. So those aren't board hearings, but they're the commission hearings on the cases that, in addition to the other kind of matters that the commission hears on a regular basis. Those are the two cases that the board has already heard are going to the commission. And that's going to be in Los Angeles. And then March 21st is our next board hearing. And there's going to be 3 new cases that we know today. There may have been a couple of others that have come in since then, but at least 3 that we're going to hear on the 21st as new cases as a board. No April dates right now. Yeah. Correct, because right now we have the 3 cases, so we don't need 2 days. We had held 2 days in case we had more cases to hear. All right. Well, thank you for the questions. Really, thank you for your time. I know it's a long day to sit through a lot of information and to weed through it, and not all of it is super entertaining, but it is extremely important. So I appreciate you all being here today, and thank you for engaging in the process. And we're going to continue to learn more about how we can become more efficient, more transparent, and just, better at what we do as we go through our 2nd year of reviewing these cases. Chandler's going to give you a quick note on, I think, getting you paid, right? Reimbursements. So important stuff.
So we do things a little differently between the 2 groups, but for the commissioners, if you require a printed copy of the letter